Where it stops, no one knows. We're going
Let's go on the record. This case is the state of Indiana versus Richard M. Allen. Are you Richard M. Allen?
Yes, Your Honor.
Mr. Allen appears in person in the custody of the Sheriff of Carroll County. We're here for an initial hearing in a criminal proceeding. Mr. Allen, we're not here to determine any questions of fact. We're here to explain to you the charges to which you're responding to, the statutes under which you're charged, your rights to an attorney, and your constitutional rights. Before we get to any of that, though, the court notes that on today's date, the state of Indiana filed a verified request to prohibit public access to a court record, and the court also, in response to that petition, filed or entered an order which can be found on the docket. Court order sealing request and court records pending public hearing. There are a system of rules called the Indiana Rules of Court Rules on access to court records, and Rule 6 allows for the request to seal records and the records themselves to be sealed pending a public hearing. And so the court has granted that temporary relief and scheduled a public hearing on November 22nd, 2022 at 9 a.m. to determine if the requested court records should be restricted from public access as requested by the state of Indiana. The state of Indiana has the burden of demonstrating that it's entitled the relief it's seeking, and the state of Indiana has to post a public notice in compliance with the Access to Public Records Act. And the court's date and time for that hearing should allow for the notice to be posted and 20 days to pass, which is required under the rules. That covers some preliminary matters that are atypical. The rest of the matters are fairly typical. Mr. Allen, if you'd raise your right hand to be sworn. That's all right. Okay, I see it. The defendant is sworn in. I suppose it's worth noting for the record, it does appear that maybe you have some protective gear on.
Yes.
I don't own a bulletproof vest, but it looks like a bulletproof vest and some other things. And so the court notes that the defendant is in custody and there have been extraordinary matters taken to protect the individual. We're here for an initial hearing. Mr. Allen, do you read and understand the English language?
Yes.
What is your age?
50.
What is your date of birth?
9/9 of 72.
What are the last 4 digits of your social security number?
Go fuck yourself.
What is your current valid mailing address, if you have one?
1967 Whiteman Drive, Delphi, Indiana, 46923.
Are you under the influence of any drug, including alcohol, at this time?
No, sir.
If at any time you do not understand anything I say, will you please let me know?
Yes.
You're charged in count 1 with murder, a felony. Count 1 alleges that on or about February 13th of 2017 in the county of Carroll, state of Indiana, Richard M. Allen did kill another human being, to wit, victim 1, while committing or attempting to commit kidnapping of victim 1. Without admitting to the allegations contained in count 1, do you understand the allegations contained in count 1?
Yes.
Count 1 charges you under Indiana Code. This statute provides, in relevant part, a person who kills another human being while committing or attempting to commit kidnapping commits murder, a felony. Do you understand the statute under which, do you understand the relevant portions of the statute under which you're charged?
Yes.
You're charged in count 1 with murder, a felony. A person convicted of murder in Indiana may be sentenced to a term ranging from 45 years to 65 years. The advisory sentence is 55 years, and the fine can be imposed not to exceed $10,000. Do you understand the range of penalties for a person convicted of murder?
Yes, sir.
You're charged in count 2 with murder, a felony. Count 2 alleges that on or about February 13th, 2017, in the county of Carroll, state of Indiana, Richard M. Allen did kill another human being, to wit, victim 2, while committing or attempting to commit kidnapping of victim 2. Without admitting to the allegations contained in count 2, do you understand the allegations contained in count 2?
Yes.
Count 2 again charges you under Indiana Code. This statute provides in relevant part that a person who kills another human being while committing or attempting to commit kidnapping commits murder, a felony. Do you understand the statute under which you are charged in count 2?
Yes.
Count 2 charges you with murder, a felony. A person convicted of murder may be sentenced to a term ranging from 45 years to 65 years. The advisory sentence is 55 years, and a fine can be imposed not to exceed $10,000. Do you understand the range of penalties for a person convicted of murder?
Yes.
Those are the 2 offenses to which you're responding to in this action. We'll now go over your rights to an attorney and then your constitutional rights. You have the right to retain and be represented by an attorney in this case. You also have the right to proceed without an attorney if you so desire. And if you do not have the money, means, or property to hire your own attorney, an attorney will be appointed to represent you potentially at no cost to you. So there are 3 choices, only 2 differences. The 3 choices are hiring your own attorney, being your own attorney, or being examined to see if you qualify for court-appointed counsel. And so 2 of those, you still have the services of an attorney. One you hire yourself, the other the court appoints. And the third being you serve as your own attorney, which I've got 3 pages of dialogue I have to read to you.
Sure.
To explain how foolish that is before I can allow you to do that, but I also must allow you to be foolish if you have your mental faculties, and that's your choice. Do you understand your attorney rights, Mr. Allen?
Yes.
And do you wish to be examined to see if you qualify for court-appointed counsel? Do you wish to proceed as your own attorney, or do you wish to have time to see if you can hire an attorney of your own choosing?
I wish to hire an attorney of my own choosing at this point.
You must retain counsel within 20 days, 20, because there are deadlines for filing motions and raising defenses. And if those deadlines are missed, the legal issues and defenses that could have been raised will be waived or given up. Do you understand that?
Yes, sir.
When the court found probable cause to support the charging information, it set bond at $20 million cash or corporate surety. This is the first time anyone's heard that, the state included. And so that's what bond has been set at. Defendants indicated a desire to hire an attorney, which is the defendant's choice. We'll now go over the constitutional rights, and then we'll set the matter for an omnibus hearing and jury trial. Your constitutional rights are as follows. Mr. Allen, as a defendant charged in a criminal prosecution, you have a certain legal and constitutional rights guaranteed to you. You have the right to a speedy trial by jury in the county in which the offense was allegedly committed. And the court is scheduling that trial for March 20th of 2023, 9 a.m. as a first setting. Did you get that date and time, Mr. McClelland?
Yes, Your Honor.
And since it is a first setting, March 20th, 2023, the court is setting an omnibus hearing for January 13th, 2023 at 9 a.m. The omnibus hearing is tethered to those deadlines that were referenced previously, Mr. Allen, and so counsel certainly must be retained before the omnibus hearing to meet those deadlines. And if you cannot retain counsel for financial reasons, notify the court at your earliest opportunity in writing, and you'll be examined to see if you qualify for court-appointed counsel at the court's earliest opportunity. Your constitutional rights are as follows, or continue. We talked about the trial that you're entitled to, and it's been scheduled. You will be presumed innocent unless and until the state proves you guilty beyond a reasonable doubt. You have the right to face all witnesses against you and to see, hear, question, and cross-examine those witnesses. You have the right to require witnesses to be present at any hearing to testify in your behalf. And at your request, subpoenas will be issued by the court requiring witnesses to appear on your behalf. You have the right to remain silent, and you cannot be required to give any testimony or make any statement against yourself to anyone. You have the right to be heard in your own defense at any hearing or trial concerning the charges against you. Anything you say, however, may be used against you. Do you have any questions concerning any of the rights that I've advised?
No, sir.
Upon finding probable cause, the court set bail at $20 million cash or corporate surety. Bail is permitted, even in this type of case. To preclude bail, the state has certain burdens to meet, although initially we could set a no bail hold subject to review, I suppose. Does the state wish to be heard regarding the issue of bail or release at this time, Mr. McClellan?
Judge, the state is going to orally move the court to consider putting a no bail warrant on Mr. Allen or consider holding Mr. Allen with no bail. I can follow it up with a written motion if the court prefers that, but I am orally moving for the court to consider that, Judge.
The court set bail upon finding probable cause in the case the defendant was unable to be brought before the court for an initial hearing, and that has occurred. The court is going to order defendant held without bail pending a formal bail review hearing, likely with the assistance of counsel. And so you've been explained your attorney rights, Mr. Allen. Pending the omnibus hearing or further bail review hearing, you are going to be held without bond, and the issue of bond can be brought before the court by written motion by either an attorney of your choosing or court-appointed counsel if you qualify. If you are unable to hire an attorney of your choosing, do you understand the process?
Yes, sir. Yes, sir.
Okay, well, we've got a trial date. We've got an omnibus date. If you're unable to hire an attorney, notify the court in writing and we'll have a similar hearing as we had today to see if you qualify for court-appointed counsel. And then, if you do qualify, we'll address the issue of bail at a formal hearing, but everything is one step at a time in all cases, and even this case. Do you understand that?
Yes, sir.
All right. Anything further today, Mr. McClelland?
No, Your Honor, thank you.
Okay. Well, that'll be the order of the court. We've got the hearing dates and times. You're ordered to appear as ordered, Mr. Allen, and that concludes the initial hearing. Thank you.
Thank you, Judge.
So everybody in chat's going to be like freaking out, like, what in the world did we just read, and why was this like so like hidden? And Sleuthy and I were having this exact same conversation. So this transcript is really very basic, nothing extraordinary, and was denied to the defense team for whatever reason. That's all.
I have some questions, and
Absolutely.
I sent Michael a link. But one thing I guess I didn't realize was, so he's telling him that he has the right to like basically be his own attorney. But in the same breath, anything he says can be used against him. It's like, how are you supposed to effectively be your own attorney if everything you then say will still be used against you in that scenario? The other thing was, I don't know if it's a fuck up by Jody, which wouldn't surprise me, with regard to how it was transcribed. But why did he keep saying that he was being charged with murder?
I'll let Michael answer, but my understanding is because everything in Indiana is under the murder statute. So it's the kidnapping is still under murder. They don't have like the same felony murder rule like other states do. Everything is under murder.
Well, the kidnapping alone is not under murder, but kidnapping plus a death is murder.
Right.
He says, wait a minute. He says, a person who kills, oh, okay. Yeah, okay, that makes sense. A person who kills another human being while committing or attempting to commit kidnapping commits murder, a felony. I guess it's just weird to me that he doesn't say felony murder, but then I forgot that that's like not a thing there. So
Well, it is a thing. It's just not called. I mean, there's
it's not
no,
called that.
I really don't know about other states. It is called felony murder, absolutely. And some people have been making talking about, like, he was charged with felony murder, but not first degree murder. No, there is no first degree murder. Murder is murder. Um, he wasn't charged with a knowing or intentional killing. He was charged with felony murder.
I have a question for you, Michael,
What's that?
about the bond stuff. So he says
Uh-huh.
that he set it at $20 million, and then he says that basically they could take the bond away, but that Nick basically has a high burden, or he has burdens that he needs to meet in order for it to stay that way. But I don't remember Nick ever doing that.
Yeah, I haven't followed the bail stuff. He was never going to get bail. I mean, that just doesn't matter. I mean,
It's
I look, I did this in a case up in Elkhart. My guy, we got his murder conviction undone. This is a kid, by the way, who was charged at 13 and convicted at 14 of murder. Um, the Indiana Constitution that was used to say, I think it's been amended, but basically between the Constitution and case by the Indiana Supreme Court, the burden is on the state to prove that the bond should be denied, and instead of putting the state through its paces on the bail question, the judge just set the bond at $1 million, which he knew that, my guy, African American kid, he wasn't a kid at that time, but he'd been in prison for literally half his life, or so 12 and a half or 13 years. He knew that he was going to have $1 million. So look, it's like the sentencing. Everybody was up in arm. It's like everybody knew that Rick Allen was going to get 130 years. It didn't matter what the lawyer said. It didn't matter what the prosecution said. He was getting 130 years. There wasn't going to be any bail.
I just thought it was interesting that he said it, and he said that, well, obviously Kathy wouldn't have been able to pay that much money. I mean, it's an exorbitant amount of money, but he said it, then he took it away, but he said that everyone's like entitled to bail even for this charge, and then took it away. And then I do remember at one point the attorneys did file a motion for bail, but then that was when everything got all weird, and then they started doing like motions to suppress. It got really muddly and bizarre, and then she wanted them to do the Franks. It was weird. But what about this transcript, other than the fact that the attorneys were denied it, is interesting to
I
you?
think the only thing interesting about it is that McClellan stood there silent,
And didn't say, I
knowing
just
that.
talked to his lawyer yesterday.
Yeah, and so it's not so in the motion to correct error, it's alleged that Brett Gibson met with Rick the night before. So I don't know whether Rick understood that he was still being represented. I mean, I don't. That's why they have hearings.
I'm wondering
And
if he was just shocked. Like he said, I wish to hire my own attorney, but I wonder if he was just too much like not realizing what's going on to say, I do have one. Why isn't he here? But
That's what I'm
yeah,
wondering. So why if the attorney Gibson knew that the next day he was going to be charged with murder, did he not know that this hearing was going to be happening?
well, there was no cause number yet. I think Tara pointed that out on Twitter at one point. There was nothing.
oh,
People are
true.
saying, well, you had to file an appearance. Well, there was nothing to file an appearance.
Well, Diener started the hearing by saying what the cause number was, but that could have existed just at that moment when he said it. But I would just wonder why Nick didn't say he does have an attorney. I just spoke with him yesterday.
Yeah, I can't tell it.
And then would Nick have to say, well, like, would he have to come forward here and say, you have an attorney, I just spoke with him? Or
I don't know what I don't know what McClelland's duties at that point were. I mean, maybe he can just stand aside. It's, this is why we have hearings.
So I'm looking at the information that was so it was filed on the 28th of October, but it says approved by me this date, October 27th, 2022. But the ones that I have, the two that I have are signed by Nick McClelland. There's no, like, they're not signed by Diener. I don't know if that makes a difference, but they say he put
Well,
the 27th and they were filed the 28th and it's not signed by Diener.
yeah. So it's an interesting question. So yeah, he'd fill out the chart. Well, I mean, there's a probable cause affidavit, and then he'd file the charging information, and then Diener would simply find probable cause. I don't know that Diener doesn't have to sign the information if you're talking about the charging information.
Yeah, I just sent the link. I assume that the charging information is what it is.
Yeah, and we don't know whether McClelland, now this is the interesting thing, knowing that Rick was represented, did he send the charging information to Gibson?
Well, it could, I guess, be why Gibson knew that. But then again, on the 27th is when he supposedly told Kathy, Gibson told Kathy, that tomorrow he's going to be charged with murder, which would have been the 28th.
Well,
So if he gave this
but,
to Gibson,
well, we know they talked on the phone. And by the way, I mean, I love, Joe Lewis is great. I called him, I guess he's moved from YouTube over onto Rumble, and he's put together a piece about hiding Rick from his lawyers, and it's interesting, but I truly don't think that this was an attempt to hide Rick from people. I think it really was, rightly or wrongly, they were worried about his safety, and so when, at least from the information we have, when Gibson called the jail, nobody knew he was there, so Gibson called McClelland, and McClelland right away arranged for the meeting. So nobody's
well,
nobody
no one
was.
knew he was there because he was under the pseudonym or
I
whatever.
understand. I understand, and what I'm saying is that up on Rumble, Joe Lewis and somebody else have put up a really nice piece, but I think they're wrong about. They may be right about the statute, that they really didn't have the authority to book him as under a pseudonym.
Yeah,
But
I didn't see Joe's thing. I am curious as to why they did that or how frequently they do that.
I've never heard of it before. But what I'm saying is, and I think I said it a minute ago, that I think they did it for his safety, so that people wouldn't come. It's a big case in Delphi, and at least until they charged him, they didn't want people to know. They didn't want the public to know he was there, but there was no effort to actually hide him from Kathy or Brett Gibson. Yes, it's true. Brett Gibson, the first time he called, nobody there knew about it, but Gibson immediately called up McClelland or emailed McClelland, and McClelland called him back and arranged for a meeting. So no, people aren't trying to hide Rick.
Yeah, I was literally about to say something about, oh, hiding him or whatever. So the 28th also is when that clip, that news clip that I'm still obsessed with, that short on my thing. That was the 28th that she was reporting on that. And she knew that it was Richard Allen that was arrested. She didn't know what he was charged with on the 28th, but she knew his name.
Yeah, and I don't know when, I don't know when that report came out. I think the more interesting thing is that sources told them that if we're talking about the
Mm-hmm.
same report, more
Idea.
interesting, the
Yep.
sources basically he was already transferred, and I think the language was to a state facility.
Mm-hmm.
And, that wasn't true. But, you know, was
It manifests.
Lesenby, I, I don't know who the sources were, but why would, I mean, safekeeping things are really rare. They're not unheard of, but they're really, really rare. And so, this is not something the reporter, him or herself, I think it was a woman, made up.
Mm-hmm.
Um, Somebody really was. I mean, there was clearly a plan already, and somebody just misreported the plan.
Yeah, because Lesenby said he had never done one before, so it's not even like really he would know to default to that. I mean, I guess Diener would know, and Nick would probably know, but even Diener would probably know, but I don't even know. Like, I was thinking about this. Maybe Nick had never done or dealt with that either. Like, we forget about Nick's very limited, and by that I mean no history of murder cases as a prosecutor. But he was a defense attorney. But I do wonder, because I keep asking myself, why didn't Lesenby go to Nick? I don't understand. Like when he needed to do this motion, I don't understand not going to Nick. Why go to Diener? And why didn't Diener say, go to the county prosecutor to ask for assistance with this?
Or the county attorney or whomever. I mean,
Yeah,
but I think the county attorney might have been Nick as well. So,
exactly. And so it's like, did he not know how to do it? And that's like Diener was the only option or whatever. But even then, even if he was the only option, that's like too bad, so sad. I don't think that's a good enough reason for him to have done it. But
well, and advising and helping Lesenby fill it out. Diener gave him really bad advice. He didn't tell him to verify it under penalty for perjury. He didn't tell him he had to serve it on. The thing wasn't even served. The request, safekeeping request, made on.
why
Uh,
wouldn't he tell him that? Like, even when I got a divorce, like, even that judge was like, you need to make sure that you serve it before we even like did anything. He was like, she was like, you need to make sure you serve him. Like, that was something that was important to tell me. And so I don't know why Diener wouldn't say, here, I'm going to help you with this. But you have to make sure you serve even Richard Allen. Let's say he didn't even know about the attorney yet. Say you need
yeah,
to give
no,
this to Richard Allen.
yeah, no, but he didn't even serve McClellan.
That is bizarre. I wasn't thinking about him not serving McClelland.
The whole safekeeping thing is bizarre. I think about any proceeding. Maybe has 6 steps, right? I mean, I'm picking six, not uh, maybe five, maybe four. You might screw one up. How do you get everything about filing wrong? I mean, everything.
Uh, I don't. What
I
if
mean, you really have. Yeah, go ahead.
somebody asked me, like, what happens if now, say we have this motion to correct error? It seems to me as though this is like the biggest piece of that. I've been saying that. So, what happens if Nick pulls out like a certificate of service? It says for some reason it wasn't filed in the CCS, but we were served this
Well, he
motion.
was served. Rick Allen wasn't served.
Could he say that Rick Allen was served and that the paperwork got lost in between the jails?
Well, the certificate of service, the docket speaks for itself. I mean, there's no certificate of service filed. There's if you look at the docket, whenever something's filed, there's like this line that says automated response, and it's like notice of sent to so and so, various people,
I just
and there's
wonder
nothing.
if they backdate stuff though, Michael. Like but personally, I think if it's not in there right now, then there is no. Here, I'm bringing you this piece of paper. I guess we forgot to put it on there 2 years ago, because I'd be like, that means literally nothing to me. You could have just typed that up. But she's bizarre, so
Well, I mean, it's always possible for
yeah.
people to try and do that sort of thing. I just don't assume they're going to.
They said he'll say Ricky ate the paper. That's what I mean. They do weird shit like that. I don't understand it.
Well, by the time Rick, I mean, it's gonna be hard to prove.
What the hell? That wasn't me. He did it. Yeah, I mean, I personally think that um even if they came up with a piece of paper that was file stamped by the clerk, I still don't think that should be accepted. So, what happened to you?
I hit the wrong button or something. Um, no, but the point is, look, this isn't going to happen, so it's really not worth spending time on. But they'd have to show how the thing got served on Rick. They'd have to show a whole either somebody drove over to White County, drove down to Monticello, or it was emailed over there. I mean,
But it still
he's
doesn't matter because he wasn't the one that should have wrote the motion anyway.
the complaint about this is not that it's not the six things that didn't happen that should have. The complaint is that Rick represented never got the opportunity to object to them. In other words, it's not the thing that was wrong with all the things that were wrong with the safekeeping hearing that's the complaint. It's that neither Rick nor his lawyer had the opportunity to to say no
At that time, as it was
at that
happening.
time. At that time, and the answer, you know, there are two answers to even if you say Brett Gibson was not representing Rick at the time, he mailed a request for counsel the
Before that, 2 days
the
before.
1st of November.
Yeah.
So, as the motion to correct error says, as a matter of law, he had a request for counsel in as of November 1st, the day before Lesenby filled out the safekeeping request, and 2 days before Diener before it was filed and before Diener signed it. And so, he had a request for a lawyer in, and they did this without the lawyer there. And then there's a third argument, which is kind of doing a little jujitsu on the Indiana Court of Appeals, and the Indiana Supreme Court. Unlike federal courts, Indiana courts hold pro se litigants to the same standards as trained lawyers. Well, if that's true, then his absence there has to be treated as if his lawyer was missing because he is his lawyer.
Yeah. Something else that people have been asking, and I was talking to somebody the other night that asked this, and one of the questions was whenever like Brad and Andy were filing all of these requests to like modify the safekeeping order, um, get rid of the safekeeping order, things like that, why this particular argument.
They didn't see it, I guess. I don't know. I haven't asked. I don't know why.
See, I
You know,
assumed if you look at the like emails and stuff, like I assumed the emails between Rosie and Gibson didn't even happen until like last week. And so it's not like they would have had the communication with the lawyer already, and they didn't have the affidavit from Kathy or whatever. I didn't know if all of those things, like, it didn't get brought up and maybe didn't realize it. I mean, I know when they obviously had a lot that they were getting from December all the way through, but somebody had said maybe she or maybe the appellate court is going to say this didn't get brought up throughout, when they were asking for modifications to the safekeeping hearing, and will they disregard it just because of that?
If you don't have a lawyer at a critical stage, it's game over. I mean, it just is. And you don't. So, and I've said this elsewhere. Thing that United States v. Chronic says is the reason that it's game over is it is not worth the cost of figuring out what would have happened if a lawyer had been there at whatever the critical stage is. Now, it's true there are more limited remedies in some circumstances. If, for instance, I think Ali Motto was pointing this out, at least in Illinois, you're entitled to be represented a lawyer a lineup. And if you're not, the remedy for that is you suppress the results of the lineup. It's not like the whole trial goes away. We'll see. I mean, look, this is an argument, and I don't have all the answers. You set arguments up as best you can. And, I was talking to one pretty smart lawyer today, and he thought the Chronic argument that Rick wasn't represented at the safekeeping hearing was pretty great. But, what a court's going to say, we'll see.
Michael, there's two good questions that I want to say to you, because I hadn't thought of this. One, Miku's headphones said not everyone has a lawyer with them at the initial hearing. They're usually public defenders on the docket to step in, but private attorneys are expensive. And that made me think of, like, the courts that I've watched where you come in and they say, do you need an attorney or whatever? And there's, like, public defenders that are sitting there waiting to stand up there with you to speak to the attorney or to speak to the judge. Is that not, like, a thing that happens there often? Or
It may be, if that may happen in some courts. Maybe in courts with greater volume. It didn't
yeah.
happen in this case. I don't think that I've seen it happen in Indiana. Mostly, it's just to get appointed. I mean, it's interesting, and so Marion County, Indianapolis. Um, they probably schedule initial full series of initial hearings, and they have a central public defender agency, and they may have public defenders go in and sit in on the initial hearing. I just don't know.
So I have
Yeah.
a question kind of in
And the
regards to
initial
that.
hearing, the initial hearing, you know, somebody the other day who was like bellowing out, we'll tell you what the law is. Spent about 5 minutes trying to tell the world that initial hearings aren't critical stages. That's where you get a lawyer. And this is not about the initial hearing. This is about the safekeeping proceeding. There wasn't even a hearing. There had to be. Um,
They must be
and
confusing this with the safekeeping here. They must think this is the same thing.
and they're not. They're days apart. I mean,
Right.
they're 5 days apart. 6. Um,
Okay, so I have a question real quick on the public defender situation, because now that we've read through this really not hugely important document of transcripts today, Diener does say that they're going to hold a hearing, to see if he qualifies for a public defender.
Yeah, he did.
But they didn't hold a hearing for that. They just gave him a public defender after he wrote that letter. Or is there something else in this whole scheme of things that we're missing? Hey, DB.
well, he says he's going to qualify. Hold a hearing to see if he qualifies. But Rick apparently in the transcript says he wants to hire his own lawyer. So look,
So
this is what.
when he wrote the letter saying I need a public defender, do they not then set up a hearing, or do they just immediately give him a public defender? Like why would he
That's what
not
I'm
have to meet the
asking,
requirements then?
Where's this hearing to see if he even qualifies or have?
I think they just look. It's 2 counts of murder. Rick's a CVS manager. I mean, they maybe should have held, maybe should have held a hearing on it,
Yeah.
but you know,
Well, I mean, he would have gotten. I mean, he would have gotten one. You know.
look. I think so. Diener recused himself on the 3rd. I mean, this was all choreographed. Diener. So they have the safekeeping hearing. Diener recuses himself on the 3rd. On the 4th, Gall shows up. I mean, this was all set up.
Skullduggery, even.
I think so. It's my opinion that when Diener did his whole bloodlust and he left, his whole thing was that people want. So everyone was requesting the PCA. That's what they wanted. And at that time, he did not say that it was sealed. Okay. Like in this hearing, he says that the prosecutor asked for to limit, so basically that people didn't have public access to the PCA. However, he also said that there was this bloodlust for something that doesn't exist. And he says, as soon as it exists, then we can fulfill these requests. But as of right now, it doesn't exist. And I know that Thien has been crazy about page 8 of the PCA. I'm just really, I'm really thinking that the PCA itself did not exist even at this 1028 hearing. So Diener's saying he found probable cause, but I don't think that it actually existed and wasn't written up until
Yeah,
later.
and that may be something for the post-conviction folks to investigate. The trial lawyers didn't. The time for motion to correct errors passed, and I don't know that anything can be done with that now.
Yeah, like
There
it's
are other
not.
there are other interesting questions about the timing of the execution of the search warrant. I just don't have the stuff, and you know, there are people out there who say defense lawyers lie over and over. Actually, that was the companion of the person who was bellowing. Will tell you what the law is. Um, and the fact of the matter is, defense lawyers don't lie over and over. And the motion to correct error was very carefully checked for fact, and we don't allege anything that we don't have. They don't allege. I was basically the paralegal, getting the exhibits together.
I heard I wrote it.
I heard you wrote it too. Okay.
I think that's possible.
Yeah, I saw on Reddit that these foolish attorneys filed a motion to correct error that I wrote myself. But
Yeah.
while we're
Yeah. Go ahead.
before we just while I'm thinking about the PCA, something else I want to ask you is: have you ever seen, or is it normal for the affiant of a probable cause affidavit to be redacted from the affidavit, their name?
No, I've never seen that, but I want to go back to the facts business again, and that is, I mean, you raised the PCA, and I mentioned the timing of the execution of the search warrant on Rick's house.
Mm-hmm.
You know, we just weren't going. Brad, Andy, and Jennifer just weren't going to allege anything that we don't have the facts for.
What can you share about the timing? And you're talking about the 13th, right? Or the 26th? Did they get another warrant?
The search warrant. I don't know enough about the search. Look,
Okay.
I've only been in this case for a year. You all been around for years and years. I just don't know enough about the facts about the PCA or the search warrant, and I'm just a clueless outsider.
I'll tell you what. I have the affidavit for his arrest, and I have the search warrant return for the search at his house, but I do not have a affidavit, a probable cause affidavit, or even request for a warrant for Richard Allen's house.
Yeah, I haven't seen it. Look, I just don't know anything about it, and so I really can't. I only know some people have raised the question of the timing, and I'm not talking about the lawyers. I mean, I've seen it out there in the world, and I just don't know anything about it.
Wouldn't they need an affidavit for that?
Yeah.
Well, and a warrant.
Well, the probable cause affidavit, you give, the
Upon oath.
cops police give a judge or a magistrate the probable cause affidavit sworn, and the judge determines whether there's probable cause to execute the warrant, and if yes, he signs the warrant, and then they go execute it. Sometimes if it's fast enough, if you have to do it fast, there are electronic warrants now, so the judge can be at home. You send the thing, the cop's out on the road, has a dog sniff or something, and sends it. Quickly types up something on the little keyboard in the cop car. It gets sent to the judge. Judge looks at it, signs it, goes back to the officer in the car, and that's the warrant. But I don't know how this is done. So.
Yeah, I'm looking at the affidavit for the arrest. Like I said, I don't have one for the search, but it says
I did locate it. It looks like
I, the undersigned affiant, which again, there is no signature page on here anywhere. And then submit the following information as a sworn affidavit setting forth the facts and circumstances, blah blah blah. Basis for probable cause to arrest without a warrant, or to establish probable cause for issuance of an arrest warrant for the above named defendant. We know he was arrested without without an arrest warrant. Oh, I did have this, but this is not an affidavit. This isn't an affidavit. This was attached for me to the return. But where's the affidavit? You have that on here? Interesting.
yeah,
No, yes,
the different font.
it is.
This is the one that they just insert the probable cause.
Yeah, it's
For
bolded.
arrest, but it's not. But it's also the wording is different, which is why I've always really leaned towards that rumor of there being two, being accurate, because
Wait, I'm lying. I totally lied. I do have this because there's
the one. It's got the return on it though too.
There's something in this. Hold on, let me go find it.
What are you looking for?
Given what happened with the safekeeping hearing, what happened and how with the search warrant, absolutely ought to be looked into.
Yeah, I'm not buying it. I'm done taking shit at face value from these guys.
What is she trying to find?
The affidavit for the search warrant.
That's this.
No. I'm looking for. This one's not it. There's, I believe, two differences in these two affidavits. Oh, here we go. It's the mention of the word gun in the affidavit for arrest. Check this search one and see if there is a reference to, as the male subject approaches victim 1 and victim 2, one of the victims mentions gun. See if there's any mention of a gun here. Which you would think there would need to be because they were looking for a gun. They collected a gun.
No, I think the other one has the gun. I'll pull it up.
This is the search.
Yeah, but I'll pull up the other one.
The other one absolutely has it. The arrest
Right.
has it, but the search, I do not. I don't believe it does, and it should surely have to, because you were looking on in the search, and you have to have
Yeah,
a
there's no
reason
gun.
to.
Well, it could be in this weird font because sometimes it doesn't pick up, the search bar doesn't pick up the weird font. But no, I don't. No, there's a few differences. I actually created a spreadsheet on the differences. I have to find it.
Yeah, that's what I was looking for, but I'm pretty sure that's the one that it is. I think that's one of them, is that there's no reference to the word. There's no
Dapping it done.
reference to the victim saying gun.
Right. I think because they were not going to be looking at the theory of charging with kidnapping at this time, probably. So they wouldn't.
So, but my question is how did they justify looking for a gun in his house for the search if there was nothing to suggest that a gun?
It's in the first paragraph.
Steve Lucy, you did write that motion to correct error.
Did I?
I mean,
Apparently,
I mean,
it was a group effort.
you
They were like, "Oh, she posted it on Twitter." So, like, I guess I just got everyone's suggestions. Pretty good job, folks. That sounded really professional.
no, I'm saying, I mean, you've got a really good issue there in the search warrant. Why? How come they get the gun if there's no gun in the application? And so, yeah, I mean,
It's right here. I mean, so in the search warrant that Diener signs, it says law enforcement is ordered to diligently search for any and all information or evidence of the crime of murder in violation, specifically to search for handguns, 40 caliber ammunition, knives, blue sweatshirts, jackets, black sweatshirts, jackets, clothing, electronic devices, and a
Yes,
cell
but
phone with this phone number.
the affidavit is what they use to then say, okay, we need to go look for A, B, C, D, E, F, and G
It's
inside
here.
that house.
Believes that evidence in the form of handguns, 40 caliber ammunition, knives, blue sweatshirts, jackets, black
Yes,
sweatshirts,
but why? But why? So did he put that a bullet was found by the girls? Because that would be the only reference. My
Yes.
point is
Yes.
when
Investigators also located a 40 caliber unspent round. They also determined that articles of clothing from the girls were missing from the scene, which
okay. So
still, once again, we don't know where those ever ended up.
but again, the difference between the search warrant PCA and the arrest PCA is that
Right.
all of a sudden, for the first time ever, and it wasn't in Ron Logan's either, for the first time ever, all of a sudden one of the girls says gun in the video of Bridge Guy
Correct.
that no one heard.
Correct.
I feel like
yeah,
because of their
and
theory.
at trial gun became that be a gun.
Yeah. So if you think about it, if they thought, let's just say, for instance, as a hypothetical, that they thought Richard Allen was probably Bridge Guy, but maybe not the killer, even if you consider it this way, how do you connect that 40 caliber unspent round to the Bridge Guy? The only way you're doing it is if there's some type of reference to a gun, or you see a gun in the video, or one of the girls says gun, or you hear a gun cock.
No, there's the bullet between them.
Yes, but what does that bullet between them have to do with the person on the bridge?
Well, I mean, they're thinking that the person on the bridge took the girl down the hill, and that bullet ended up there, and he controlled them with a gun.
Yeah, but I think the whole point of what Sleuthie's saying is there was not a gun until they found a bullet. Like that wasn't important until they were like, oh, we're going to match this bullet to Richard Allen. So it's not put into any of the affidavits until they actually want to arrest him on the 28th.
Well, it wasn't in Ron Logan's search warrant affidavit either, and they were going in to collect
with
guns.
Ron Logan's is that they already went into his house without a search warrant because he was on probation. So they didn't need a search warrant, so we don't have that. They already went in and took all of his guns.
So you're saying
the search warrant is the second one that they needed to be able to.
I think the dimension of the bullet, if that was in the application for the search warrant,
yes,
the dimension of a bullet, a 40 caliber bullet between the bodies, is enough to include gun in the
right.
search.
No, I agree with that. I'm just saying what happened between finding Richard Allen's gun that holds 40 caliber bullets to before you found that all of a sudden now this video says gun.
Well,
Yeah,
the FBI might have not.
I can't tell you. I think everybody reported hearing guns.
Correct.
I have no idea.
Except Liggett, he heard that be a gun.
All, I can't argue with you. I mean, yes, you pointed out the discrepancy. There's nothing you can do with it at this point. I mean, it's a discrepancy. Yes, somebody maybe needs to go listen to the thing. Maybe somebody needs an expert to go listen to the thing or look at actually the voice print of the recording. But got people saying that be a gun. You've got people saying just gun, and then there's no gun mentioned earlier. Yes,
So
there are these three discrepancies. What do you want to do with them?
so let me ask you this. I charge you with felony murder because even if you point the gun at the girls, say you're on the bridge and you point a gun at the girls and you say down the hill, and you send them down the hill because you're an asshole, you're like the troll on the bridge that doesn't want them to cross. And then you turn around and you leave. And they go down the hill and someone murders them. That's felony murder. Because you
Yeah, maybe not. I mean, the, the cause of the nexus, to use the word,
mm-hmm.
might have been broken. In other words, you kidnapped them, but it wasn't while you were kidnapping them or attempting to.
So is kidnapping not as simple as they wanted to cross the bridge to go back and I forget the saying, like something their direction of travel, like you prevented them from going.
Right,
Impeded.
right. It used to be called confinement. Now it's called kidnapping. But the point is that the kidnapping, if you force them down the hill and then walk away, the kidnapping's over.
So if they then were murdered by entirely separate people, you would not be considered, like, had you not sent them down the hill, they wouldn't have died. Would that not be
Um,
the argument?
I think the defense is, look, I mean, a prosecutor might try and make the case. I think the defense is that it wasn't while someone was kidnapping them or attempting to kidnap them. The kidnapping was over. Crimes end.
Hmm. I still think if we find out tomorrow that there were more rounds at the scene, like spent and unspent.
which
There
would
were
have been
definitely,
told them.
well, and that's another thing to look into. There were definitely spent rounds there.
Okay, so that's a huge problem for me because my big issue has been, how do you make that one round, that one particular round, relevant unless you can make the guy on the bridge have a gun? The guy on the bridge has to have a gun for that particular round to have any meaning.
Well, I think that they always thought the guy had to have a gun because they do have the gun. They pull Brad Weber's gun. They pull Logan Maxwell, or actually it was Maxwell's dad's guns when they do the very first, or rumored to be the second search warrant, but whatever. The Maxwell house search warrant, they pull guns from there and don't get a match. So, I mean, there has to be something
Well, they
to it.
found the round.
I don't understand why. My whole thing was, if you have all these other rounds and you're also in a flood zone, how do we know that these rounds even matter?
That's what I'm saying.
But they
How is
obviously
that
always thought
round?
they
How's
mattered.
any of the rounds relevant? Any of them, unless the guy on the bridge has a gun. How do you show the guy on the bridge has a gun? One way you could is if one of the girls says gun, or you see a gun, or you hear the gun cock. If none of those things happen in that video,
Or I have Apophis does some photoshopping, shows there's a gun.
I kind of disagree. I mean, I don't think you have to show the guy. If you think the guy on the bridge was involved in kidnapping the girls and getting them down the hill. And there's a bullet down there. Even if there was another person, it might be the guy. I mean, probable cause is a really low standard.
I know.
They really, I mean, and that's the thing. I mean, people don't really realize this. I mean, there was, on any reasonable view, there was probable cause to arrest at least one other person long ago. There was probably probable cause to arrest Ron Logan.
Sure.
And they didn't. And look, I don't have the answer to the question of why they didn't. I don't have the other evidence they have. Maybe there's certainly other evidence that makes Ron Logan look guilty as hell. I'm not saying Ron Logan did it. I don't know what's in the discovery. I don't know what the state has. I don't know how they cleared him.
You don't? You don't have all this information?
There's 20 terabytes of stuff. I mean, I have seen what was necessary to prepare the exhibit for the motion to correct here.
I was joking. I thought we had seen all the discovery and also engaged in fuckery with the jury. But I'll throw something else at you about this bridge guy. So
maybe it'll stick.
in Ron Logan's search warrant, in his search warrant, one of the things that they say about bridge guy in particular, so let me get to the bottom. They say why they are suspicious of this bridge guy. Because I don't want to misquote it.
Oh, why would you care about anything like facts, Lucy?
You mean, yeah, I probably should just paraphrase it all wrong. Oh, here we go. So it says a suspect has been developed, blah, blah, blah. 43 seconds from the phone where the suspect follows the victims as they're walking on the Monon High Bridge Trail. Near the end of the video, the suspect speaks to the victims, saying, "Down the hill." It sounds as though he is directing the victims to leave the trail they were on, and enter the wooded area below. No person has come forward and identified himself as the person who met the victims and made the statement in LG's video. Therefore, it is believed that person in LG's video participated in the killings. Now,
is that kidnapping?
No. What I was gonna say was, and there was other references to this about how the reason that they knew that Bridge Guy was the killer was because nobody came forward and said that they were Bridge Guy or the guy on the bridge. So if they're saying that Richard Allen is that person, and he did in fact within days of the murder, before this affidavit and everything was written up, wouldn't that mean like the person did come forward then and say that they were there? Like, do they become not suspicious now?
It would mean that, but it would also could mean that, they didn't, I don't, so this is the FBI, right?
Yes,
and
this one.
I don't know I don't know when they saw Doolin's tip. I don't know when Doolin's tip made it into the Orion file. I have an idea from a couple of things, but I don't know.
Well, this was after Kathy started working there, so.
Yeah.
You know what else?
All I'm saying is, yeah.
I want to know where the underwear and sock is. That's what I want to know.
Well,
I wonder if they would have. There's search warrants out there that were never done, and so I just wonder if like the underwear and sock is there.
Here's a really good comment. This is kind of what I was thinking too. Travis, a lawyer, he likes to say on the internet.
Which one?
Travis Williamson.
Yep.
Yeah.
No,
So he said,
which comment?
what?
I meant which comment I was going to click it for you. Go ahead.
Oh, okay. It could have been a cigarette butt instead of an unspent round. What counts as probable cause is a different analysis as to what is sufficient evidence, circumstantial or direct, to convict. And it seems like there would be enough specificity in what they were asking for in the warrant, right?
Yeah, very often you're not going to arrest some. I mean, the double murder, I'm not sure, but to me, in a lot of cases, you're not going to arrest somebody often until you've got enough evidence to convict them. And in other circumstances, you're going to arrest them. You're going to execute the search warrant. They did it sort of in reverse with Rick. I mean, there are different ways you can do it. But, you're not going to charge, even though probable cause is a low standard. And, you can arrest somebody at the drop of a hat. A prosecutor, and certainly in a big case like this, is going to hesitate to do that until they think they've got enough evidence to convict.
I just have so many problems with all of this.
Well, yeah, I mean, it's a big case. There are a lot of different people working on it. I'd want to know, we go back to shell casings that were found. I'd want to know if they were .40 caliber, and did Oberg or anyone else compare the actual fired rounds with a fired round from Rick's gun. I don't know where the shell casings were found. But to go from a legal point about Ron Logan and his confessions and the box cutter and other details, and to go to Bridge Guy again. One reason Ron Logan makes a whole lot of sense is that he says he recognized Abby. And the reason that, in terms of the Bridge Guy photo, and look, I have everybody and his brother looks like Bridge Guy. I'm not hanging anything on Ron Logan looking like Bridge Guy. I will say this: he doesn't. The thing that makes him interesting is he doesn't not look like Bridge Guy.
He also apparently doesn't. His voice is not inconsistent either, according to the FBI. But they also say that his physical build is similar to Bridge Guy, which when you put him next to Richard Allen, it seems like, well, how can that both be true? How can both of those things be true if Ron Logan was like 6'4" or whatever he was? I mean, he was very tall. He was a tall man.
Well, the FBI saw the original video. I haven't. I don't think, frankly, you can tell anything much from either the Bridge Guy still or the Bridge Guy or the 3-frame interpolation that they created and released to the public of Bridge Guy, because I think that is just a complete infection.
Yeah, I agree. And also, what's interesting about the Ron stuff with the Davis confession or whatever is, and this doesn't have to only apply to Ron Logan or this particular statement, because it could certainly be applied to others as well. But it seemed very consistent for me with regard to how Abby was treated in comparison to Libby. I know that people talk about like a target and stuff, or what could the meaning be behind the two differences. And I've always said that I don't think it's weird. When they were talking about moving and staging, I kept going back to this thing that I had read that the FBI wrote, actually, where they're talking about things like this. And in particular, people that will like stage a victim, especially if you're talking about like redressing them.
Are you talking about an undoing?
Basically, like sort of, but more or less, like, okay, so it gave you this case example of this man who killed his wife, like, in the middle of the night, and posed her in a way that suggested that she had been assaulted, and it was all very brutal. And then, like, he went downstairs and was in the kitchen and called the brother, like his brother, to come over and check on her, and said that someone had broken in the middle of the night. And basically the whole thing behind it was he made it look like a stranger. He wanted someone else to find her first and made it look like a stranger had done it and she had been assaulted when there was no evidence of that. So you have staging there. Well, then you have like other people who find their loved ones deceased in some type of way that they want to preserve their dignity. So not necessarily feeling bad about having committed a crime, but you don't want the person that you have these feelings about to be found in that manner. So they'll like cover them up with a blanket on the bed. They'll pull them down from whatever apparatus they're in, and things like that. And for me, that's always what I felt Abby, that she was given more respect in that sense, to keep her dignity. And I just feel like
So,
it would.
that makes sense on the one hand, but can I go back to the like actual facts of this one? And so tell me if I'm wrong, Felicity, the FBI search warrant affidavit says that Logan's phone was at or around the bridge at 2:09, right?
Yeah, well, yeah, I'll tell you exactly
Well,
what it says.
I think it says that. But you fact check me while I go on.
It says that he makes a
Um,
phone call, and in that phone call, it says he's in or around his property in the area of the Monon High Bridge Trail.
at
I
least
think he
in the
was.
yeah.
I think he was so close to the bridge that I think that the FBI didn't put like, what are those numbers called? DB, what are those numbers called?
IMEI,
No, coordinates. They did not put
yes,
coordinate.
longitude, latitude.
Longitude and latitude.
So, like,
We don't know exactly where he was.
right. Now, the ones that are at like 7 o'clock and 10 o'clock, they put him near where the girls are. So they're much closer than the bridge thing. But yes, he was on the phone at 9 or 2:09.
So the legal point about in the motion to correct error about the Ron Logan stuff is, once court testifies about box cutters, all of a sudden, I mean, that casts a whole new light, right, on Logan's supposed confession to Reese Davis and somebody else, but Reese Davis is who's in the motion to correct error. That's the legal point. If you want to go to the factual stuff, if you look at the Snapchat picture of Abby at 2:07, there's nobody behind her. And if you want to create a narrative, it makes a whole lot more sense that Ron Logan is crossing the bridge and passes the girls, recognizes Abby, in other words, after 2:07, passes them on the bridge, recognizes Abby, and then turns around. And that's why he's behind her. And
Well,
then,
that's actually what I do think. I do think whoever it is coming from the south side and turns around.
yeah, I mean, it almost has to be. And it kind of fits with, Ron Logan saying he knew one of the girls, and that her mother worked in a bar. I mean, that's Abby. And and the horse thing. And again, I am not saying Ron Logan did it. I'm saying these facts seem to fit. Look, they're trying. The state tried to make up a case out of practically nothing, saying these facts fit Richard Allen, and the facts as we know them from and hard to call them facts yet. I mean, it's an alleged confession. Why they have hearings, and that's actually why, in light of the box cutter testimony from Core, Reese Davis should have been permitted to testify at trial, or he should, the third party evidence should have come in on him. And because, whether to believe a jailhouse confession or not, that's a credibility question for the jury.
Well, I've
Well,
seen
to
a
your
lot of people.
go ahead.
I've seen a lot of people trying to make the argument against a motion to correct error as one that is kind of blowing off Ron Logan as a suspect because of this confession not being, credible enough for them. And my argument to them is this is not a actual innocence argument. This is a legal argument about what happened at trial. And, people are saying, well, they've already had it. Well, that's not the standard for newly discoverable evidence, right? So the standard from reading the motion to correct error, I believe, is that it was undiscoverable before with due diligence because a fact wasn't known at the time, i.e. Core, having this epiphany about the utility blade.
Yeah, that's the theory. That's the theory. I don't say it wins. It's I think it's correct, and it should be taken as such. Look, when arson science changes, I mean, there's a woman, Christine Bunch. She's on actually the board of the New Innocence Project. She's been exonerated. She was convicted of setting a fire that killed her daughter, I believe it was, in a trailer. And arson science change proved the whole state's theory was nonsense. And she got her, in a post-conviction case, she got her conviction undone by calling the change in arson science newly discovered evidence. Well, of course, it's not newly discovered evidence, really, is it? We know more about the evidence that was there. We know more about what the evidence was because science has changed. Well, we with respect to third-party guilt, with Core's testimony given for the first time at trial, we now know more about Ron Logan's confession or his alleged confession.
Well, something on that too that's interesting is like how the newly discovered evidence in this case that you're talking about, fire science, somebody that progressed that along quite a bit was William Tobin.
Oh, the metallurgist.
Yeah, the metallurgist.
The metallurgist.
Metallurgist.
No, just metallurgist.
Michael, we know.
I can't say it right, so they make fun of me.
Oh, okay. Wow.
But also, there's some things though in that Davis thing. Like, I get that some of it is, you could say that it's inconsistent, but there's other things though besides the recognizing Abby. Like, for instance, the whole idea of him going back later on when the search was happening and trying to move them. Well, then you have his phone pinging. He's getting and sending text messages at that time when the search was happening. And not for nothing, but I've heard people say, like, why would he go out there while the search is happening? Well, if he says he's going to search his own property and people think he's out there searching, and this is obviously just a hypothetical, but if they think he's out there searching on his own private property for the missing girls, I don't know that in that moment anyone would consider that he was doing anything else besides searching, just like all the other people that were out there. Like, there were tons of people out there searching who knew what they were doing.
Yeah, and I'm going to leave it to you all to explain why, all the reasons Ron Logan's confession has legs, and was it really Ron Logan? The real point of all this is that it's pretty compelling stuff for any number of reasons. and the jury should have been able to hear it.
I think if they were going to bring in Richard Allen's confessions, then I don't see how it wouldn't have been relevant for the defense to be able to bring in everybody's confessions. Like, even if you're not naming them, like, even if you're saying, you know, John Doe 1, John Doe 2, these people all made confessions also. So if the question is who confesses to something that they didn't do, well, here's 50 people that confessed to something they did not do. And they weren't in prison when they did it.
Yeah, I've made that point. I mean, that those confessions don't come in as evidence of third-party guilt. If they don't come in as evidence of third-party guilt, if you, law enforcement, and Nick McClelland and Stacey Diener and Jim Luttrell say all these people were cleared, that means that all of these were false confessions. Basically what you said, Lizzie. And so, the jury should have heard that these people, and so you don't, right? You're not admitting the confessions as true. You're admitting them as false to prove that people on the state's own evidence falsely have confessed to this crime. And by the way, none of those people have been in solitary confinement and involuntarily medicated with Haldol for 13 months.
Michael, have you ever read the Ricky Davis 2019 appeal?
Have I ever read what?
Have you ever read Davis's appeal for manufacturing methamphetamine?
The one done by John Chenoweth?
Yes.
I actually know a bit about Reese Davis because I was looking at some stuff for him way back when.
And Stephen Owens. Do you know Stephen Owens?
Steve Owens appears. So Steve Owens had the position Amy Carrozos has now. So Steve Owens is the Indiana public defender. So the public defender's name appears on every pleading under the deputy who's filing it. It's the same as, so the Attorney General's office, the Deputy Attorney General signs it, but underneath that, there's Todd Rokita, the Attorney General himself as well. So it's not, Steve Owens had nothing to do with that.
Okay. When I first heard about Reese, I looked him up and I found the appeal, and it is fascinating.
You sent it to me?
Yes, and it's a side.
What's fascinating about it?
Well, so this guy ends up calling the cops on himself. He tells the police, "I've been doing meth. I'm strung out. I don't know what's going on with me. Like, I'm dying or something. Come help me." So the cops show up, and they say it smells like ether, and drug. It appears there is equipment outside that is consistent with somebody who would be manufacturing methamphetamine. That there's another person there. He's like, "I'm thwacked out too. We're fucked up." Like, they're tripping. The cops go inside, read them the Miranda rights. There is nothing. There's no meth, but there's this manufacturing stuff, right? Well, he ends up getting arrested for it. Come to find out, there is a old YMCA boys camp, I think 990 feet from the corner of the property.
Don't even get me started, DB. I have spent so much time with Google Earth and and the youth center on the other side.
You have a map of this case. It's insane because it's over 1,000 feet. Sorry, go ahead.
Yeah, and it actually makes a difference in that case and exactly where in the house the stuff was found.
About 38 years difference.
Yeah.
Well, that's fucking
the dude
weird.
Got 40 years.
50.
50.
Yeah.
This guy didn't hurt anybody. I mean, you could make the argument that allegedly manufacturing methamphetamine, which there was evidence that he had some of the equipment, and having a history of marijuana possession, one count, one count of minor in possession of alcohol equals a criminal history plus the 1,000 feet. They had the state GIS person testify that it was within 1,000 feet, but you could literally just measure it from the desk of the person's office, and it was 1,014 feet, and it would have changed like 38 years. Well, I mean, if it's 50, if I got that wrong, I mean 48 years. The guy didn't lie at trial either. His whole trial was about that. He called the cops, said, "Dude, I'm thwacked out. Come get me." And then basically said, "Yeah, I was doing that, but like I wasn't 1,000 feet." So the dude literally like seems
So
like
was he actually
pretty
manufacturing
honest.
anything?
Well, I mean, what do they got to do to prove that you're manufacturing methamphetamine? Like it's laid out here in the appeal, and they're talking about some of the supplies that he had and stuff like that. And I mean, I've read the Anarchist Cookbook. I mean, it sounds like something you could use, like, but I mean, there was no residue. They had pseudoephedrine pills in empty boxes, empty water bladders, cold compresses, ammonium nitrate that was extracted, some lithium batteries. And I mean, like I said, yeah, I mean, that might be a meth starter kit. But, it wasn't, they weren't distributing it. There was no proof of distribution. There was no proof of
The starter kit.
Yeah. I mean, if you look up the Bridge Guy starter kit, there's the meth.
But does he say that he was manufacturing? He just says he's high and he's losing his shit.
I mean, they might have said that, but like there's other elements to it, I think, than just. But he stipulated that he'll say, "I'm going to trial on this other shit, but like these are the things that I'm gonna preserve for appeal." And there was a Creech, obviously you know what Creech is, but there's a whole Creech thing about entering a plea on another one of those enhancements that he got or something like that. But it's very interesting.
Yeah, send it to me when you get a chance. I'd like to read it.
Well,
I haven't read it. I haven't read much about that guy.
Well, there were 2,000 feet things, and so there was a church sort of diagonally the other way to the northwest that had some sort of youth programs in it. And one of the claims was that the statute about being within 1,000 feet of a youth program center was unconstitutionally vague because you didn't have any notice really that the youth center was in the church. And there's actually a seventh, and I think John Chenoweth is just an unbelievably killer lawyer. He's one of the two lawyers who runs the wrongful conviction clinic. So he's a deputy public defender in Amy Carrozas' office, and he and Jamie Ackland, Amy's chief deputy, both run the wrongful conviction clinic at the law school in Indianapolis. And John is just a killer lawyer. I mean, he is amazing. And
I mean, he definitely went to the mat on this case, and that's impressive because.
And he did the state court work in Dwayne Dunn's case, which is a case that ended up with. So we won the case in the Seventh Circuit, and Dwayne ended up being exonerated. Basically, it was a murder that wasn't a murder.
That's a new blood science, right? That was your case that they tested. There was a bad blood science at trial,
No,
right?
it wasn't about. No, it wasn't about blood science. It was about. No, it was. There was a fight, and this guy fell fell down some stairs and over a railing and hit his head on the concrete and died. And it took 2 years for the state to do it, but they charged Dwayne, and they had a pathologist say he'd been hit on the head, even though there was no murder weapon or anything. Dwayne had gone down to help him, and his public defender didn't get an expert in, and John got an expert in to say, no, it's a fall. I love the testimony, and I will never forget it, at least until I succumbed to dementia. And the pathologist that John got, it was a beautiful line that said, on cross-examination, the prosecutor was pushing and said, no, to me it was a fall all day. And so for ineffective assistance, the Seventh Circuit basically ordered the state to vacate his conviction or cut him loose. And the state realized they had no case, and so they didn't retry it, and so that counts as an exoneration. So that's a long story about John Chenoweth, who, as you say, he went to the mat for Reese Davis.
Yep.
And I guess I didn't go. I guess I didn't go to the mat for him. What can I tell you?
Well, you went to the mat for Dwayne and some other folks, right? I've read some.
Well, I spent a lot of time on Reese's case. Don't get me wrong. I spent a lot of time looking at it, and what people don't realize is that, whether something can be won in federal court depends in very, very large measure, almost exclusively, but maybe not quite exclusively, on how the state courts decide a case. And in the end, there was just nothing that was likely to succeed because of the way the state courts had handled Reese's case. There was really nothing I thought that I could do for him in federal court, and it would be, right? You can go and fight the good fight. And if I had a whole bunch of lawyers like Amy Carrozza's office, I might have done that. But it was me and my students, and like if we're not pretty certain we can win, we just can't spend the time doing the case. It's not a, and it really was about the way things shook out in state court.
Speaking of that, is the safekeeping hearing and the chronic issue, some people have said, well, why didn't they bring that up before trial? There's obviously the fact that they may not have known, right? They may not have talked to Gibson, all this stuff. Rick was in the depths of hell and WCU, all this, right? But you can't have a chronic claim pre-trial, right? Like that's a post-conviction issue.
Yeah, it really is. It really is a post-conviction issue. I think the tragedy here is that I think Rick could have been gotten out of solitary immediately
by going straight to Fed court.
Yeah, I think they could have filed 19. It is just a due process violation. I've said it over and over and over. It's a due process violation to keep pretrial detainees in conditions that equate to punishment.
Right,
and that's not in the law. That's 1979.
Right, because most people would say, well, is it cruel and unusual punishment? A layperson would think, but really it's because he can't be punished whether it's cruel or unusual or just normal, right?
It's not an Eighth Amendment claim. It's a due process claim, yeah. So it's a 14th Amendment claim, not an Eighth Amendment claim. At least that's what the Supreme Court has said. I could see it, how a court, the law could develop so it's an Eighth Amendment claim. It's cruel and unusual punishment when he shouldn't be being punished at all. But, the Supreme Court said it's a 14th Amendment due process violation to treat somebody that way pre-trial. So, got to kind of go with what the Supreme Court says, right?
That's the Metropolitan Correctional Facility case, right?
Nope, that's Bellevue Wolfish.
Oh. Oh, look who's in the chat. R&M Productions. Hi, R&M Productions. Big fan.
Me too.
She's
Things
great.
are. I don't know, T. You're letting things get awfully cranky on your live.
Am I?
Well,
I didn't know it was getting cranky.
You got two or three cranks.
Cranks.
Well, I think we just we, what do you call it? Gravitate to each other.
What happened to this channel?
I do. I get that one a lot. What happened to this channel? What happened to you, Teresa? And I'm like, I don't think anything happened to me. I feel like I'm
the trial.
The trial, I guess, happened when it comes to this case, but I mean, this is just. I think I'm still just me. I don't know.
It was funny the other day in Peter's lot. There was like 4,000 people. People were going in and like saying, "Hey, fellow cranks" and stuff like that. And there were other people who were super confused. It felt like an inside joke. It was kind of cute.
Yeah, we gravitate to each other. It's like we know each other.
Speaking of channels, can I say
something? I was going through some of the document, different things as you guys are going through things. So I'm here. I'm listening to everything. I'm just trying to find other stuff that about the topics that you guys are kind of talking about.
Speaking of channels, can I say something about what's been alleged to be my YouTube channel?
Oh yeah, please do.
Go ahead. I'd love to hear this.
So there have been folks out there talking about how sort of unprofessional it is to put these video exhibits up on my YouTube channel. And I don't have a YouTube channel. Anybody's got a Google account automatically gets a YouTube account with it, right? I mean, you sign in, same thing. And those videos that are exhibits to the motion to correct error are not public. Anybody with a link can get to them, but they're not searchable. They're not in any sense a channel, and they're, at least the original file's a big file. And I just put it up on YouTube because it doesn't use any quota. And the link, if you give somebody the link, they can get to it. I could have used so I'm using it as a server, and I could use a Dropbox link. I could do some sort of, put it up as a Google Drive thing with a view-only link. But there are courts and other people who can't get to Dropbox, but everybody can get to YouTube, or just about everybody. And to the people who say that those links were not for Judge Gull, they're wrong. The links and the thing was put up precisely to make it easy for the courts to get to them. Somebody can say, well, there are other ways. Yeah, there are probably other ways, but it's the YouTube site being used as a server. It's not me putting these things up on my YouTube channel.
I kind of thought maybe it was the professor in you, because when I was back in school, a couple of years ago now, I guess it is a couple of years ago now, I had to turn every video presentation I had to do, I had to turn it on YouTube, which was interesting when you have a YouTube channel. You know what I mean?
Yeah, the video stuff for the law school, I do, through Canvas and Zoom and what's it called? Geez, there's a thing that turns your Zoom videos instantly into videos on Canvas, and so the students have them. So yeah, no, this is the first time I've ever put the only other thing that I've ever put up on that channel just to save it, and it's not a channel, up on that site, was a video a friend of mine did back in 2015 when I got the Gideon Award from the Indiana Public Defender Council, and I gave an altogether too long speech, but my friend of mine did the video of it because my wife and child could not be there because they were across the Great Water. So, the idea that I have a YouTube channel is hilarious. And
So what you're saying is all of us that went and subscribed when we were looking at the videos, we shouldn't expect to hit anything?
No.
Damn it.
No. And it was fun to get all the emails too about people subscribing.
Yeah, I subscribed. I'm pretty sure I subscribed to it. I was like,
Well,
hey,
Nick-
just in case, I want to get notifications if something does pop off here. So I need to
Nick
know.
McClelland, he did say recently that the only reason people are helping out is for clicks. So I thought
that's
it was
true.
prudent that Michael just created a quote unquote YouTube channel and got some subscribers. I figured that would be fodder very soon for
Oh, I'm sure it will be.
detractors. They also
Well, I know
said
there are people who are discussing that, how good of an attorney can you be if you're an attorney that's just on YouTube?
Yeah, well, I don't think I'm just on YouTube. I'm only recently on YouTube, and but
It wasn't just you. It was about some of the other attorneys that are on YouTube too. But it was just kind of funny because
in all fairness, I mean, Bob Motta is quite upfront. He's not practicing anymore. He's doing the podcast and YouTube thing. I mean, that's a job for him now.
But I guess for me, I'm just like, I'm not an attorney. So turning to attorneys that are actually taking to YouTube and using it as a platform to educate people on, very specific things. And even what I do know is more about like trial court versus anything that's post. So like you coming on is always an education for me, telling me all the things that I don't know, like post conviction. But I don't know how does anybody go on and talk about a criminal case or any type of case in this genre and not actually listen to somebody who has experience in the courtroom or doing these types of filings? Or how do you not want to listen to that?
They're just complaining. They just want to say something rude. They just want to come at your personal character or what you do every day because they think that's what's going to hurt your feelings. But then the issue with that is Michael just doesn't give a fuck. Neither does Bob.
Michael
Bob
just
could not
doesn't have
care less.
feelings.
Yeah.
He's
There you go.
legal
So,
theory.
this video has 1.1 thousand views on Michael's channel.
And not one of those is probably gold yet.
Is that a lot? Is that a lot?
I mean, it's good
a
for
lot.
somebody who has 134 subscribers.
You had 44 yesterday.
I mean, you're
Popular.
blowing up.
Grifter. Now you're a grifter and a crank.
Well, they're not monetized, so you can't really grift.
Oh, that doesn't matter. I'm not monetized.
Well,
but
I'm
you
going
grift all
to
over
say something.
Twitter,
There's a pair of lawyers out there, and it's really an incredible disservice to the public. There's a pair of lawyers out there who, they have a podcast and they put up a tweet saying, no big deal. These post-trial motions are filed all the time. And, people are just doing it for money and clicks. And it's like, I got to tell you folks, I haven't gotten a dime out of this case. I'm actually about $1,000 in the hole because I've supplied some high capacity hard drives to the defense. And I don't get any money from clicks. And so these people have, who I assume are competent lawyers, just they misstate facts, they misstate the law, and it can't be that they don't understand it, because I assume they're competent lawyers. So it's intentional. It is intentional. It's lawyers out there intentionally misleading the public.
Yeah. Well, then they'll say, if you say, well, I'm not making any money and actually I spend money and blah, 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 you say all those things. And then the argument switches to, well, then you're just stupid. You're doing all of this for free and going out of your way, and you're not even using the attention that you're getting to make money. So it's like a losing argument. It's absolutely pointless. Everyone's just bitching. If they liked you, they wouldn't be saying any of these things. Half of them are in the exact same. In fact, 90% of them are doing exactly what they're saying that you're doing, except you're actually being helpful. They're just doing it just to do it.
Well,
Like they will literally talk about people grifting and then like thank someone for a super chat.
that's kind of where I'm at with the whole thing. It's like
So I don't care.
You're talking about other attorneys and doing this type of thing as your attorneys who are doing that exact type of thing.
Well, you don't want competition. They want the money to come to their channel, listen to what we say. So if you say things that sound better than what we're saying, then people are going to come over to you and we're going to lose income.
You know, I don't know all the details of it, but the Unmentionable podcast, whom I call the Tweedles, you know, their copyright claims, at least to, you know, their copyright claims, some of them at least, absolutely have legs. I looked it up. And again, you know, somebody knows more about copyright law than I may say I'm wrong, but from what I can tell, if you do a broadcast, the transcript of the broadcast is subject to the same copyright as the broadcast itself. You know, they do make money off of the clicks and the downloads and the rest. And I can't, you know, maybe for internet etiquette purposes, it's not playing nice, but I think they at least kind of have a legal point.
Here's the thing. Those transcripts have been typed up, publicized. Like somebody on Reddit had to literally, because they copyright struck like a post on Reddit for the transcripts. That person had to go back and take every single transcript down from the course of the last couple of years to make sure that they didn't go through and copyright so many times that the entire subreddit got the boot from Reddit. So it was never an issue until now. Like, it's going to be difficult for anyone to try to say to me that like these one after the other after the other after the other of all these state actors going on that podcast, all of them, Diener, Liggett, Luttrell, Nick, Holman, Cecil, or not Cecil, Cicero, like all of them. And I'm sorry. And they're putting out their book. Like every single thing says, go order a pre-sale of our book or whatever. Now, all of a sudden we can't share the transcripts because they want people to come over and listen to what they're doing on the podcast, see the thing for the books. And it just feels very much like, if I was going to be a tinfoil hatter, I would say that this is what they'd been waiting for this whole time. Like it almost looks like something they were promised. I mean, the news is not getting interviews with Stacey Diener, but they're going on the murder sheet where they talk about burger murders.
And you can complain about, you know, where Stacey Diener and all these people are going for their interviews, but I'm sorry. I think they've got a good copyright beef. I mean, they're in the business of doing this. I mean, what can I
My
tell you?
annoyance is them not
I'll
caring
politely
all
disagree.
along.
I'll politely disagree on the copyright thing. If you're just sharing the transcript on another platform, it doesn't really make sense when the transcript is available to the public to go and download.
And Teresa made a good point. Most of the people that are reading the transcript aren't going to be listening to, like, they're reading it so they don't have to. These people aren't, like, if they can't read the transcript, they're just not going to go listen. They'll have other people tell them what it said.
Where Teresa is the transcript of, let's say, of Holman's interview? Where is the transcript of Holman's second interview available on the internet that is not related to that podcast?
Hold on. What do you mean?
Well, you can go on where the podcast is and you can download the transcript without listening to the episode.
They have the transcript on their on the website.
Yeah, like
Are you talking about the other channel that did the interview?
Murder Sheet.
No,
He's talking about Murder Sheet.
Oh, you can go to their podcast and you can download their transcript.
well, fine.
Is that derivative?
Then they get a click from their. They get a click. They get money from that download.
No.
I just I can't see how it's even debatable.
Well, then I just won't talk about anything that they're doing, to be honest, because I will not be referring anybody there, number one. And number two, I think it does get to a certain degree. If I create a channel right now specifically to rebroadcast all of their episodes, let's say, then I would probably be a little bit butthurt about it if I were them. But if it's just these like post-trial interviews and people are,
You don't get to say.
well, I understand. I'm talking from
I
my
guess, are
own
you talking
personal
about just
point
like
of view.
sharing? Are you talking about just sharing the transcript as like a link on its own, or are you talking about like the read-throughs like that we've done?
He's talking about sharing the transcript. He's talking about if you share the transcript, you're taking like that click from them,
I
from
don't
whoever
think
accepts it.
that. I think it's a derivative art. Like
But
it's
I
a.
don't get paid per clicks. Like on YouTube, we don't get paid per how many people click on it. I get paid for how much you listen to it.
Yeah, but that's different with the podcast. That's how
Michael,
many
how
downloads.
come we didn't strike them for something when they put the private messages out there on a 5-part episode?
I don't know.
They're not copyrighted.
I don't know that we have a copyright on that. And the other thing is, not only do we not have a copyright on it, I mean, look, I mean, people were saying, oh, invasion of privacy. No, the stuff was, there was somebody on there who had access to it, and like we'd exposed that stuff to that person, and that person, I mean, we could hardly claim we had an expectation of privacy and that stuff if
I just
that
don't
person
know.
could.
The fair use thing is a legitimate thing. So like Hidden True Crime, for example, me and Teresa did 2 parts on that, and we figured it out. It was like an hour and 40-minute full, like the full interview was an hour and 40 minutes. And in the 2 parts, it took us five and a half hours to get through an hour and 40 minutes because of so much commentary. And when I actually, she filed a complaint with the copyright something board. It might be copyright complaint board. And then she submitted that to YouTube as that being her, because basically they have 10 business days to provide proof that they've taken you to federal court in your jurisdiction over this copyright issue. But they have this copyright board that is an alternative, but it's entirely voluntary. And both parties have to be willing to participate in it. And the people who determine the copyright claim are copyright lawyers, not a judge. And so she filed it there and essentially said that she did not like my commentary, so that wasn't considered then commentary or fair use, because she didn't like the things that I said, nor did she like the title being pig roast. And that the only relief she was seeking was that I not be able to repost my videos. Not that I took money from her, not that people were watching mine instead. Oh, and then she said she got like mean comments. Well, the mean comments I saw were all because when she took down my videos, it literally says, this has been copyright struck by Hidden True Crime. And then people go over there and they say, why did you copyright strike that? That has nothing to do with me, and it doesn't have anything really to do with your interview. It has to do with you copyright striking it. So it gets
I
to.
I don't know what YouTube does, and I'm not enough of a copyright lawyer. I think the transcripts. It's an interesting question. Could you take the transcript? If let's say it's a 20-page transcript,
Mhm.
and if I basically annotated it with an additional 10 pages of footnotes, right? Commentary. Is that a violation? Is
That's
that a copyright
transformative.
violation?
Is it transformative? Have you transformed the purpose of it? So if you've now
Look, I can't tell. Look, I can't tell you. If you want to go to court over this shit, go to court over it. Sue them. But
oh no, I have no
the,
time.
pro-
Well, see, that was the
the
point. Was she was supposed to sue me, but instead did this copyright
right,
whatever that we
A CCB.
is it
right,
copyright
and the
complaint?
nasty thing about copyright law is that I believe the presumptive damages are and again, I'm not a copyright lawyer, so don't. I mean, you can check it out, and then presumptive damages, I think, are $250,000, and nobody. So when somebody goes after you for copyright, the law is set up for people to, you know, remedy the situation or settle in a huge hurt. It's not right, it's not fair, but it's the way I think the law works. And I'm just saying, crabbing about copyright shit. I mean, yeah, I mean, you can say nasty things about them, but again, I don't think the commentary should. If you've got 5 hours of, you know, if 4 of the 5 hours are commentary, I don't know why that's, you know, struck. But if you're in the YouTube universe and that's how YouTube does it, all you can do is work around it.
So if you want to be a copyright lawyer, all you have to do is just Google the laws, and then Indiana will qualify you as a copyright expert.
It's a lot like it's a lot like water and dirt and a phone, right?
Exactly. You could just be an expert in just a matter of 10 minutes, Michael.
Okay, so listen to this. So this is when I was considering responding, but again, who has the time and I have other shit to do. This says I can't say the name. I can't pronounce it. It starts with an H versus Klein, and this is in 2017. It says it has been decided that in most cases, when using content in a reaction video, if there is significant commentary in a way that shifts the focus away from the copyrighted content and instead focuses largely on the input of the creator, then the use qualifies as fair.
Fine. I mean, great. You've got the case. Argue it. I can't
No,
tell
I don't
you
have time. I'm just saying, I don't have time.
exactly. And so they're pigs, and
Well, that was,
HTC.
to be fair, that was to Holman. Like, that was obviously, it was very obvious to everyone that was there that we were talking about Holman. And 90% of what we were talking about had nothing to really do with her at all. But when you're talking about, I don't know, when you're talking about YouTube, I get plagiarism and things like that, not being able to put out somebody's work as your own work. I would never post someone's entire video with zero commentary, nothing to say, and just putting it on my page and saying, watch it here instead of there. That's ridiculous. Yes, thank you, DB, but I still can't say it. Oh, shit. How do you say that, Michael?
I'd say
Hassanzada.
what? I can't. Oh, hang on. Oh, so it's in.
Hassanzadeh.
What?
Hosenpfeffer.
Hussein Zadeh.
Hosen. What?
Hussein Zadeh.
Wow.
Holy crap. I never would have got that.
See, even if I was going to argue this, if this required me to speak out loud, it'd be over. They wouldn't be like, that's not even a thing, whatever it is you're saying.
We can just stick with wheat. It covers everything.
Wheat. But wheat says.
So I have to ask a question. I'm totally going to switch up the subject here, but I have to ask this, Michael, especially because you're here. Because this seems to be like the fodder all over social media about this filing is in the exhibit regarding Reese Davis, that there is polygraph results. Have you commented on this yet, by chance?
No, and I'm not going to.
Okay.
Wait, and you didn't read Kara's thing. Read it. I know you pulled it up like 50 times.
Okay, so I don't know what this is. People are saying it's polygraph results. It doesn't make sense that the polygraph results would be in the middle of the investigator's handwritten notes. So I'm just going to stay with that until somebody can actually prove that they are. It just doesn't make sense that they'd be right here. But
can you go to that page real quick and I'll explain it?
Oh, you can? Okay, thank you.
Yep, here we go. Ready? So this is what the police do when they have an undereducated person that probably has a learning disability or, have been affected by the criminal justice system. They put their piece of paper down and then they hook a bunch of instruments up to them and they say, be truthful. You could get the death penalty. And then they write shit on the back of this piece of paper, right? 7, 5, -1, P. They draw a line and then put a -3, right? And they say, you were dishonest afterwards. Why did you lie? The polygraph says you lied.
They can lie.
That you lied? That's all this is.
Yeah. And also what I found interesting about this is so a polygraph is usually 3 or 4 questions. It's not an extensive interview hooked up to a polygraph. It's usually a couple questions. And so the fact that he had so many notes about this, he did not just polygraph him. This is an actual conversation. So the guy that did this
go ahead.
Didn't ask about every single detail about what's written here and then decide if the polygraph said that it's true or false.
Look,
They could have asked something.
This is why. Look, by the way, if that is the result of a polygraph, I just want to point out to the people who think that defense lawyers lie and this is all cocked up. This is how the exhibit. This is how the notes appear untouched. Right? We could have pulled this page out.
Yeah, exactly. They're saying that it was accidentally, you guys forgot to take it out.
Yeah, we can't win, right?
No.
What are they saying, that it's inadmissible because it's a polygraph result?
Well, they're saying that whatever Reese Davis says doesn't matter because this right here shows that he's a liar.
And polygraphs are bullshit. And a jury, if they ever heard Reese Davis, would never not know anything about this if this is the result of a polygraph.
Exactly. Angela's been taken to the argument that Ron Logan also failed his polygraph, so what would it matter?
Well, and polygraphs are crap. I mean, I know the CIA. So the CIA, I don't know about the FBI and the CIA rely on them a lot for their own personnel purposes.
So does the FBI.
How do they know what the questions were? The questions could have been, did you have anything to do with the murders of Abby and Libby? Do you have any intimate knowledge of the murders of Abby and Libby? Were you a witness to? You know what I mean?
Yeah.
We don't know what these questions were.
We don't even know if that's what it is. I'm just
correct.
There's nothing here that even says that's what it is. So I'm just.
All I can say is this is why we have hearings.
Well, not if you're in Judge Gold's court. She doesn't like hearings.
Well, and if she doesn't like hearings, then the Court of Appeals is going to have to take everything as true and everything's dandy, and Stacey Juliana and Mark Lehman can use whatever they want to out of the motion for correct error.
And also, let's be so for real. Do you not think, what do you think the odds are that police, quote, cleared folks who failed a polygraph they gave him? Because I found it really funny that Holman keeps telling everyone that Richard Allen wouldn't take a polygraph, yet that's the last note we have about Elvis Fields, is he wouldn't take one either. But he doesn't seem to think that's suspicious.
You could throw all that out. If you want to argue polygraph, all that. One of the most interesting things that will tell you about what the police were up to at that time is they assigned somebody in 2023 to go follow up on this. They didn't know that this already existed. Who the fuck is running this investigation that you assigned another detective, another investigator in 2023, an ISP to go Go investigate this confession.
It was
Like-
Kathy Shank. She didn't know that Ron died. Then she said, "Oh fuck! Nobody went and go talk to him. Now we got to shut it out because Ron died."
But Reese's not dead.
Listen,
Hobbs isn't dead.
listen. You guys aren't blessed with the brain and thought process of a Kathy Shank. Okay? She knew what she was doing. And Richard Allen was already arrested, so it didn't matter to nobody. She went on a clearing spree, I'm sure. I still don't know why she's in there as an investigator. Deputy No Badge Kathy.
Officer Kathy. All right,
Is it Daffy or Doofy? Well, I literally pictured a particular guy. Do you know who I'm talking about? Now I have to find him. I think it's Officer. Somebody's gonna know. Officer Doofy. Now I have to find it.
talking about from Scream?
It is Officer Doofy. That's literally what I just pictured. From Scary
You're talking
Movie.
about, Scary Movie.
Whatever.
That's
Okay.
what they just said, and then that emoji popped that immediately in my head, but with Kathy's face.
Oh, that's Dewey and yeah, Doofy. Okay, sorry. Okay, so you wanted me to look at Kara's tweet. So this is taking us back to the conversation we just had about the YouTube, using the YouTube in illegal filing. So we're kind of backtracking here a hot minute. I had this up, so I don't know if anybody already read it, but Kara says, no, it is not unprofessional or improper to use a link to a YouTube in illegal filing. The opposite, actually. It's a sign that the trial attorney understands how the appellate courts work. Since the pandemic, law clerks for many of our appellate judges have hybrid schedules that allow them to work from home. The deputies in the Attorney General's office have that same flexibility. In the old days, when we had a video admitted as an exhibit, it went up on appeal. The video could only be accessed by the law clerk getting the video from the appellate clerk's office. The same was true of the judges who wanted to view the video, and the Deputy Attorney General who needed to view the video. They all had to get the actual exhibit from the appellate clerk's office, and they couldn't all have the exhibit checked out at the same time, obviously. But when a link to an uploaded video is in a court filing, anyone with a link can simply click on it and view the video. They don't have to go anywhere. Why not provide a different link such as to Dropbox? Well, some attorneys do. However, in the past, I personally have had problems using a Dropbox link because some have complained that the state's IT department will not let them download Dropbox on their state-issued computers without jumping through a bunch of hoops, but they access YouTube just fine.
And that's why, by the way, the other thing I did for the lawyers in the motion to correct error was I hyperlinked the cases. And I don't know if, and this might be something your audience might be interested in. Google Scholar has, it's almost like Lexis or Westlaw. The cases it has, and you can link. So, they're not the official reporter things, but I don't know whether a court has Lexis or Westlaw or something else. And so if I link to a case on Google Scholar, everybody can get to it. And by the way, Google Scholar actually has pinpoint sites. That means to the page. So in the column, in the white space next to the text are the page numbers, and if you click on that page number, that goes to the top, and the web address goes to that page. So all the hyperlinks in the motion to correct error. So the lawyers put the cases in, and I went out on Google Scholar and actually got the hyperlinks to the page where those propositions appear. It's a different world.
Well, getting more tech, and this is actually not even like the high tech. This is just simple tech that I can even do.
Yeah, it is. And but the point is to make it simple for the courts,
so that they can even do it.
Yeah, so that they can to make it easy for them to, read what you're saying. And also, to me, it's also a matter of credibility. If I'm going to say the case says something, and I can actually send a judge to this place where it says it, I hope, and it does say what I say it says, I hope that judge thinks that gives me some credibility.
Well, it does probably in the court, but it probably doesn't on some of the YouTube streets. But it's all relevant. Okay, so I have to ask you about this too. So she actually posted this one earlier, and I was going to ask you about this when it was on here. So she talks about, she's responding to somebody who's saying that the remedy for him not having an attorney at the safekeeping proceeding is not a new trial. So it says, again, a new trial is not a remedy for that. A new trial can't do a thing to change that happening. A new trial would be no different than the trial he had after that happened. So she says, like, to talk to you and that you might be able to explain more. So this has been a frequent question after the filing of the Richard Allen motion to correct error. Many have asked how a new trial can possibly be a remedy for Rick not having counsel for the safekeeping proceeding. Here's my understanding, and you, habeas, could explain more or tell me if I'm wrong. There are certain stages of a criminal case that we consider critical. What that means is that they are so important and so case altering that it is necessary that the defendant have the assistance of counsel. These stages change the entire trajectory of the case. The stages are so critical that we don't have to show how the entire case was changed. We just know it was. That's what the claim is in Rick's case. The safekeeping proceeding was critical to the case. Anyone who has followed this case and is being honest about the facts can see that his placement in the DOC changed the entire trajectory of his case. If there were no confessions and if Rick could have fully assisted his attorneys with the case, how might this case have been different? Giving Rick a new safekeeping proceeding won't fix anything. The only fix, if indeed there was a violation, is a complete do-over. Everyone has to start back at before the alleged violation took place and go from there, and that's a new trial. So can you elaborate on this and tell me why?
No, I mean, that's really it. I mean, so there was this case 6 weeks ago, maybe, from the Illinois Appellate Court, where the lawyer had been, so the defendant had testified, and he was going to, cross-examination was going to happen by the prosecution, but it was the end of the day, so the cross of the defendant was going to happen the next day. And the judge ordered the lawyer not to talk to his client overnight about the case.
Okay.
Not just about his testimony, but about the case.
So he's not represented.
Well, more or less. And the Illinois Appellate Court said, sorry, but, you might have been able to order him not to talk to him about his cross, but you couldn't order him not to talk about the case, period. And we are constrained to reverse. And all I can tell you is, and the guy, and the comment by the brother, he's not entirely wrong, but he's not entirely wrong that it'll just be a do-over and not much will change.
We could take a do-over.
But it's a do-over. I mean, that's the argument. Look, I don't know what the Attorney General is going to say. I don't even know if Stacey and Mark are going to use the argument in the appeal. That's not up to me.
So that was my question is, so if it is a do-over, what does it change in the trial? Is that something that would be...
You just go back to square one. I mean, it's really not going to change really anything in the trial. Because you don't know how. So so the case that this is based on is a 1984 case called United States v. Chronic. And what Chronic says is, look, there are critical stages. If you don't have a lawyer at that stage, it is simply not worth the cost. That's what language they use, of trying to figure out what would have happened if there had been a lawyer there. And yeah, I mean, a court could say, I suppose, since this doesn't change anything at the trial, but you don't really, with chronic, you don't really do that. You don't even look forward. So the question is whether safekeeping hearings in general are a critical stage. Do they have, in the language of one Supreme Court case, do they have a significant consequence for the accused? And I've got some bail case, and we know safekeeping hearings do, clearly. I mean, both as a theoretical matter and as an empirical matter. And I've got some cases that say, bail hearings are critical stages. Don't have a lawyer at a bail hearing, it's game over. New trial. And this is very similar to a bail hearing. What would having if you reverse because there wasn't a lawyer at a bail hearing, what would having a bail hearing change? What would the absence of the lawyer at the bail hearing change at a new trial? It's sort of the same situation. And yes, there aren't any cases on safekeeping hearings because safekeeping proceedings, because they're really rare. Chronic cases themselves are really rare. It'll have to be fought out. I'm not saying it's a lay down winner.
So it just takes me back, I guess, to the same conversation we were having the last time that we were on here about the fruit of the poisonous tree. Like, if it's ruled that he should have had somebody there to advocate for him, and you can't go back and redo that, and he's already there, then what is the remedy? How does it not throw out anything that's happened since he was there?
Well, if the lawyers had made the argument, I mean, at a second trial, maybe somebody will make that argument. Nobody made that argument this time around. It's waived, which means it can't be raised on appeal because nobody made that objection below, raised that issue below. I certainly would have made it if I'd thought about it and been in the position to do it, but it wasn't done. So yeah, maybe second time around.
Is that an ineffective assistance claim?
I am not commenting on ineffective assistance.
My bad.
These lawyers worked so hard and did so much. What they did or didn't do, I'm going to leave, or should or shouldn't have done, I'm going to leave for somebody else. I mean, I've commented a few things I think they should have done. I mean, I think they could have gotten Rick out. I think they could have gotten Rick out of solitary right away. I think they actually could have gotten him off the safekeeping thing right away, because the whole safekeeping thing that Diener did was nuts.
Have you heard of a case where you think the attorney did a good job that they had an effective assistance of counsel claim? The defendant?
Well, what can I tell you? I did a direct appeal after a retrial for somebody that I'd taken to federal court. And I am currently being alleged ineffective in the direct appeal.
And sometimes
I think I did a terrific job, and I still could have been ineffective because I might have missed something.
Right. So
in fairness, all the defense attorneys have gone on now on interviews and stated things that they even wish they would have done differently or thought about differently at the time. So I don't know if that necessarily would even equal ineffective. It's just like, it's hindsight is 2020. There's things that they know they didn't know then, or didn't think were as important then as they ended up becoming. And I agree with you. I think they went above and beyond. And I also don't know about ineffective counsel based on the Supreme Court even calling them out on. So if you get back on this case after all of this, are you going to just turn around and appeal if he's found guilty and use ineffective counsel? So I don't even know how far that would go.
That's only going to go. That's all. Basically, the only thing that was waived by that was claims of ineffective assistance up to the removal.
Well, but safekeeping is up to the removal, right?
Yeah.
It's a tough spot for you to be in. I understand. It was a bad question by me.
No, it's not. It's not a tough spot. I mean, I can say that. So, any ineffective assistance claim involving this trial, and by the way, this ineffective assistance is not going to be in the direct appeal.
Yeah,
It'll be for the post-conviction case. But any ineffective assistance claim is going to be a cumulative ineffective assistance claim, which is to say, there were several errors that were serious enough that together deprived Rick of a fair trial.
Not strategy issues, which to me, on the face, maybe leaving in some of the stuff, knowing that they could get the DOC footage in. I mean, that seems like a decent strategy to take. If it meant not calling into question the safekeeping, you get to show that this person's confessions were done under these circumstances, right?
I'm talking about undoing the safekeeping order in
Okay.
December 2022.
Was there any part of the appeal process where Judge Gall won't be a part of it anymore? After the motion to correct error, right?
Well, the only place Gall might be involved in the direct appeal is if the Court of Appeals sends it back for a hearing on the motion to correct error.
Could they call Gibson in that?
Sure. And would.
I would imagine. That'd be interesting. Boy, would
so
that be interesting.
essentially, after she decides whatever she's going to decide about this motion to correct error, that's the last duty she technically really has on, because she won't be the judge of record once everything is settled with the clerks, right? I mean, once they have all of the records and everything is in order for the appellate court, she's gone unless the appellate court sends something back to her. Is that right? Bueller?
Did Luke curse him?
I don't know.
Luke got him.
Luke got him again.
DB, if an appellate court reverses because of safekeeping issue, is it also possible that they send it back to a new judge and disqualify Gall? That's a great question. I was wondering the same thing.
That's where I was going to go with that too. Yeah.
Yeah.
So wait for him to get reconnected or be able to hear us again. He got Mullen. Fucking Mullen deleted him.
The Gideon Award that they didn't talk about. I was reading. We all know probably the Gideon versus Wainwright, but the Indiana Award.
I like that you think that everybody knows that.
Well, I mean, people have probably heard it before, you know.
They have, but I just think it's funny. You're like, everybody knows this case. No, they don't. Hey, Paradox.
My bad.
Go ahead. Tell them.
I think I closed the tab out, but the award is given to somebody who's shown an extreme dedication to furthering the craft of criminal defense. The highest award a public defender can receive in Indiana. It's interesting that they didn't talk about Michael's speech about that.
That who didn't talk about it?
Well, they were talking about his YouTube channel. That Michael was saying that the reason he started, or not channel, according to Michael, the reason he first uploaded something was that it was his acceptance of the Gideon Award, which I think is substantial to report on if you're calling into question the attorney's ability to understand the law. I mean,
they don't care about that kind of shit. They
seems
just
prestigious.
I don't know if he's coming back or not, so we might not get answers to those last couple of questions.
They got
But
him.
I am very curious if it does go back for a retrial. Does Gull automatically sit on the bench, or is there? How do they get a new special judge? Like, that's what I want to know. Yes, Ginger Snap. He is, I believe he's her stepson. Didn't we figure that out a while ago when she very first got appointed? I think it's her stepson. I think Ben is Stacy's stepson. Is that right? Don't quote me on that, because I feel like I might be wrong.
I remember a cold chill going down my back when I first heard that, and I just got the same chill. So
okay, so I must be right then.
It might be right.
Okay, he's back.
Michael, what are the chances that Gull is not the second judge on the retrial?
Now he's
Not
muted.
second judge, but
Hey there, sorry. I keep forgetting how StreamYard drains batteries.
Oh, that's okay. Sleuthy's phone died too, so she Irish goodbye us. So a two-part question. First is, after this motion to correct errors is ruled on or essentially ignored by Gull, and all is set up for the transcripts and everything for the, I said it much nicer the first time, but for the appellate court, Gull is no longer the judge on record, correct? Unless the appellate court sends something back for her to have to redo. Is that correct, or am I wrong?
There may be stuff that was done off the record, and there's a procedure will be in front of her.
Okay. And then, so the second part of that question then becomes, if it is sent back for a retrial or a new trial, does Judge Gull automatically become the judge on that case again? Or is she replaced with a different special judge?
You know, on the one hand, it's somewhat uncertain, but I think so. I mean, it's still the same cause number. It's still the same judge, as far as I know.
what did they got to do? Could they could obviously refile to get her removed, right?
Yeah, absolutely, and they should have filed to remove her. They should have filed to remove her.
50 times.
They should have well, no, two times, at least one time.
Okay.
When she set the contempt hearing.
Oh, yeah.
It didn't bother to put it under its own number. She filed it had it all filed under Rick's.
She had no. Yeah, they should have filed an original action saying she can't do this, and they should have included in that they should have included in that. And by the way, you can get rid of her.
So then, if we have a second trial, then how would, like, Rosie, Baldwin, Ajay be automatically his defense attorneys as public defenders again, or does somebody else get appointed and they have to come in?
That's an open question too. I mean, on the one hand, it would make sense. Look, it would make sense to have. It would cost Carroll County a whole lot less than getting new lawyers in who have to get up to speed. It depends on whether Andy, Brad, and Jennifer want to do it. I think they do. And it depends on what Rick Allen wants. I assume he'd want Brad and Andy and Jennifer back. Look, it depends on a lot of things. It's I don't have a crystal ball, but my guess is comes back to Gull for appointment of new counsel. Is Gull going to appoint Brad, Andy, and Jennifer again?
No. No, she's not.
But it's better that way, kind of, right? Because you get the best of both worlds.
I don't think she gives a shit. She wanted them gone in the middle of the whole thing and told them a week beforehand to stop even talking to anybody or working on the case. She doesn't want them there. She doesn't care how much money it costs. She's not paying for it.
Well, I think she does actually. I mean, she has expressed concern about how much money it costs, but yeah, I don't know. I can't tell you how it plays out.
I didn't know if there was like a set protocol on how that actually happens.
I think it comes back. Rick doesn't have lawyers. He asked for the appointment of public defender again, and I think the whole appointment process starts over.
Well, in the Cam case, Aaliyah won the appeal, right? And then she did the retrial.
Stacey Oleana, yeah.
Oleana, yeah, I'm sorry. So could that have happened as an appointed representation? Like she was appointed for the appeal, won the appeal, then got appointed for the retrial.
Yeah, I think that's right.
Okay.
And I think that's right. And again, I mean, from the point of view of the county budget, I mean, having done the appeal, you know, she doesn't know everything about the case. And I got to say, Stacey and Mark are going in. You know, they're busy lawyers. They haven't been paying attention to all this. They know they probably know almost nothing about the case at the moment. Boy, are they going to be surprised.
Call me. I got you guys.
But from the point of view, you know, Dave Cam's case, you know, it clearly. I mean, it was like, so in this case, I told you that I'm being alleged ineffective in. It was a lot cheaper for the county to appoint me to do the new direct appeal. Actually, it was a new direct appeal after a retrial, and it was a lot cheaper for the county to appoint me because I knew the case, because I had it for 2 years in federal court. Maybe not quite that long, maybe a year.
So in Indiana, in the Cam case, like I thought there was more of a direct appeal specialization in Indiana. And so it did surprise me when Ileana ended up doing the retrial. But is that more common than it appears like from an outsider or layperson?
Yeah, there's some lawyers who do appeals and do trial work, and Stacey's great at both. I mean, she's a force. So is Mark.
Mark
I mean,
is
I
too.
have, you know, Mark did an appeal for 2 of his clients who got, actually, no, he did the direct appeal. He did the appeal. He didn't do the trial. I've got 2 of Mark's cases in the Seventh Circuit at the moment. By the way, both of them are chronic cases.
Ironic. Well, we got to see Mark in action at the Supreme Court, so.
Yeah, and you know, Mark did a great job. Mark is he was a little bit of the breathless trial lawyer up there, but and that's fine. I mean, that's a style too, and he was successful, and I thought he was really good.
You mentioned one time. Oh, sorry. Go ahead.
No, I think they made a strategic decision. I mean, I think I was worried that they weren't making the. I was worried that they weren't making the argument that Brad and Andy, at a minimum, had to be put back as counsel of choice instead of justice fees. And you know, it worked out well because the Supreme Court went with that. I mean, it's lay down law. I mean, when Brad and Andy showed up as so-called pro bono counsel, as counsel of choice, in other words, lawyers that Rick wanted, and so they were showing up as private counsel. Gull had no authority to say no, none. If you're as long as you're a licensed lawyer and you don't have an actual conflict of interest.
Under wheat.
Yeah, well, Matt Goodwine had ate too many Wheaties.
Does he have
Is that
was
who that
he-
was? I never even remember his name.
Yeah,
Didn't he work in
that's Matt
healthcare?
Goodwine. We were. He was doing stuff in the Attorney General's office when I was there long ago, and wishing it still helped. Yeah, that was Matt Goodwine.
Were you
We
a
just call
defense
him
attorney
Puppy.
before you were at the Attorney General's office?
What?
Were you a defense attorney before you went to the Attorney General's office?
Well, so I clerked for Justice Sullivan on the Indiana Supreme Court for 2 years. And then for 4 months, I was doing a little private work. I was basically unemployed. I think I was the first unemployed, and the Twitter universe and the Reddit and YouTube universe are going to have fun with this. I was the first former Supreme Court clerk in living memory to be collecting unemployment.
That'll get clipped, and then I'll get him for copyright.
And I did work on in the 4 months, I did work on one death penalty case with a former professor of mine. And it was, so I left Justice Sullivan's chambers in August, and I was a deputy attorney general. I got that job in March.
I was trying to find a case. I think I was trying to find the Dwayne case the other day, and I stumbled upon a case where there was a Deputy Attorney General Michael Alsbrook on it. So I was wondering,
There are about 86 of those.
dude, that fucking sucks for whoever fucking filed that shit.
And 9 months at the Attorney General's office, I was 86-0.
How do you look back on that time? How do you look back on 86-0? Like, do you think maybe from the other side you could?
Like most of the cases were really easy. There were only about 5 cases that I really had. There was really any risk of losing. I liked the work. It was I liked the work, and in fact, it's altogether possible I'd still be there, except they reneged on a deal. So I live in Bloomington. There, AG's offices, and this was like way pre-pandemic. But I wanted to work at home a couple days a week. I mean, I wasn't answering the phone. I didn't have any clients. I was in the appeals division. It's like all records, all paper, and they promised me that I'd be able to do that, but that I had to wait. There was an election, and Pam Carter was on her way out as Attorney General, and I forget who was elected after her. I don't know whether it was Modisette. Anyway, somebody new was elected, and they welched on the promise, and I said, "See ya."
Ooh.
Any of those 86 cases you would have won against yourself if you were the defense attorney? Like, there's probably a couple, because I read one. I was like, this does not sound like Michael Alsbrook argument. This sounds like he would have cooked this argument if he was the appellate attorney.
I think there were. I think there were a couple or 3 I might have won if I'd been on the other side.
Okay, that's not bad. I mean, that makes sense.
Ask Ariel's question. Hold on. Where is it at? I'll ask it. Let me find it. Hypothetically, if someone's a prosecutor, what's the best way for that person to eventually do defense appellate work? Asking for a friend.
Yeah. That's an interesting question because, obviously as a prosecutor, you've done the trial stuff, and because all the criminal appeals go to the Attorney General's office, which is, for instance, it's the reverse of the way things work in New Jersey. So in New Jersey, all the prosecutors' offices do their own appeals, and there's a central office for defendants and their appeals. So it's kind of reversed. Here, there's a central office. The Attorney General's office does all the criminal appeals for the state, and the appellate lawyers are spread all over the state. I'm hoping to get that changed. But I think the only way to do that, the best way to do that, look, if you want to do appellate criminal work, sometime in the AG's office is great. I mean, it's high volume. I filed 7 briefs in a day. I wrote 7 briefs in a day.
And you won them all.
Yeah, well, as I said, there was really only a very small handful that there was any risk of losing. Look, a lot of appeals are just something people do because they have to get onto the post-conviction stage. What's this question say? Random question. If you opt for a bench trial, can you still appeal? Yes. But a bench trial is, one of my former professors, actually the same one that I worked on this death penalty case with, used to say that a bench trial is nothing but a slow guilty plea.
I would agree with that.
Bench trials are really bad ideas because what happens is every objection, whether it's sustained or overruled, the appellate courts assume the judge knows the law and disregarded whatever. A bench trial is very hard to appeal successfully. It's easy. Just doing it's possibly easy enough, but winning is hard.
So DB Radar wants to know if you're discussing the Abbott twins, and if you are, maybe Michael Osbrook would be interested.
The Abbott?
I'm not familiar, so I just read the comment.
Yeah, I'm looking at the one that's up on the screen.
Oh, hold on, I'll grab this one then. Hold on.
No, somebody was asking, I think, what are there things that, as I understood it before it disappeared, things that repeatedly contribute to wrongful convictions?
Yeah, we'll do both of those.
Yeah, I think Barry Scheck has identified, I think the top 3 are bad IDs, the use of prior convictions, and I want to say bad science, but somebody else would know better than I. I did read a book of Barry Scheck's a long time ago, and those may not be the 3 that he mentioned. He did mention 3. I know eyewitness IDs is one of them. Yeah.
Oh, so I just popped back into my head. The one case, I don't know if you're going to be able to remember this one, but the one case that I was like, this doesn't sound like a very Michael Osbrook argument, was that it was newly discovered evidence. You were the deputy attorney general. It was a newly discovered evidence case, and it was that juvenile minds, the science of juvenile learning changed. And that new science was newly discovered evidence, kind of like the arson with Christine Bunch that you were talking about.
Yeah, I wasn't deputy attorney general on that. I actually took that guy. Are you talking about Donnell Wilson?
Oh, that sounds. Yeah, that might be it. So you were you
Yeah.
representing him on that one?
I was not representing him in state court. I represented him in federal court, and actually a student of mine argued it last May, I want to say, and we lost over the summer, lost on rehearing, and it's actually a pretty crazy, we really should have won. It's really a crazy opinion by the Seventh Circuit.
Oh yeah, this is the one, I think. I must have just got it backwards. 100 years. Donnell Wilson serving an Indiana prison sentence for 100 years for committing 2 murders when he was 16 years old.
Yeah, and it's a really sad story because, I mean, by the time he was 16, he'd been shot twice. His mother, I mean, they lived in a combat zone. I mean, his mother, they all, when the shooting would start, they'd dive, under the windows. And it's hard to imagine the circumstances in which some children have to grow up in this country. Just terrible.
So the district court said you weren't time barred, but then
Seventh Circuit said we weren't time barred. No, Seventh Circuit said we weren't time barred either. So there were 2 questions in the Seventh Circuit. I don't want to get in the weeds on this because it's a lot of habeas procedure. But so there were 2 questions. There was question 1, which was about whether we were time barred, and the Seventh Circuit said we were not time barred. But because of the way they answered that, we really had to win. We should have won question 2 and didn't. So all I can tell you is federal courts can be as weird. I mean, nobody who's familiar with habeas law who's looked at this says this makes any sense. So it's not just me. It's not just my sour grapes at losing.
All right. Sorry, I was just reading comments in chat. Make sure there's anything else for you. You guys have any more questions for Michael or for DB? He's a plethora of knowledge himself.
Yeah, I guess I feel like I'm being stalked out there on the internet by DB.
I just trying to find some good cases, and
that's just how his brain works. He likes to know all these things so he can come on and educate us.
In
the meantime, well, until Michael gets on, usually.
I don't know. I mean, this is like the legal version of This Is Your Life or something.
That would be interesting. We could go through all 86, see which ones you remember.
Do a whole live to see. So what do you think about this one? And what would you have done to argue against it?
That's right.
All right. Well, I'm going to wrap it up because I'm going to go figure out dinner because my kids still haven't eaten yet. So I'm going to do that. But I thank you guys for coming on, and Sleuthy, wherever you ended up. Also, I don't know if anybody is live. I don't know if I should reroute you guys somewhere, but I'm sure you guys will find where you want to go.
All right. Bye.
You guys have any final thoughts that you want to share before we wrap up?
Thanks as always, T, and thanks for that transcript.
Oh, yeah. You're very welcome. As soon as I got it, I was like, oh, I know who needs this.
Yeah, it was already too late.
Yeah. Well, you think the timing on that was interesting? I figured it would be.
I think the timing's interesting, and but the good news is that if there is a hearing, it's very useful to have it, and I really, really appreciate it.
Always, anytime. So I do have the rest of the transcripts from the July-August hearing. She said she's working on them because, we didn't get all of them. So she said she's finishing those up and will let me know as soon as they're done. And then we have the request in for the trial transcripts. I don't know if there's anything else that we would be able to get at this time through her, but that's kind of where I'm at.
So, I mean, you're not paying for the trial transcripts.
I will pay for them, yeah. After appeal. After they're done for the appellate. So there'll be $1 per page.
You shouldn't have to. They
Mm,
should be public record. You shouldn't have to do that.
okay. Well,
Once the transcripts are ready, let me see if I can help you out with that.
well, that would be great. Yeah, that's the big one that we're waiting for. So we have the rest of the ones from July, August, and since they're going to be prepared for the appellate attorneys, I'll pay $1 per page, which we were going to have to pay the $5.75 or whatever. So hopefully it's $1 per page now that she's doing it for them. And then and I just put it in the pre-request. I've done it a couple times now just to keep her, reminded that I want them for the trial transcripts. And she did say that they would be $5.75 per page. And I was like, no, I don't want them until after the appellate attorneys, are going to need them. And at that point, there wasn't one yet. Obviously, there was no appeal or anything, or appellate attorneys even appointed. And so she was like, well, if there isn't one, then you have to pay the $5.75. And I'm like, well, there will be. So I'm not worried about that.
Okay, here's the deal. I think once it's on file, once the transcript's been filed with the Court of Appeals, I think that you can get them. I think you can get the transcript for $30. We can talk about it later. I won't hold you. You got to feed your kids, but there are easier ways. I think you can get. I think it's if you send $30 or $50 to the clerk of the Court of Appeals, they'll send you the transcript on a CD.
Well, that would be amazing. So yeah, if you can help with that, I would love your help with that. And I'm sure that the crowdfunding would also help, would be very thankful. So, we do have the sentence. I know the sentencing hearing on the transcript has already been out there on social medias, but I have my own copy coming so that we can do what we do with our transcripts and have it, on our criminality record. So we'll have that too, even though I know it's out there with other people's watermarks. So that's where everything stands with that.
Well, thanks again.
Always thank you.
And I haven't been following the chat. I hope I've helped with some stuff anyway.
Oh, they're good. Yeah, I tried to pull up any questions that they had for you. They just put in there like question for Michael. I tried to give it to you or just ask you. So yeah, you're good. I appreciate you. They appreciate you. We love having you on. It's just always so helpful for understanding all the things. I will say I was pretty disappointed with this transcript. I thought that it was going to be something like bigger that they were not wanting out there, but it is what it is. We got it, and here it is.
I gotta say, it's almost exactly what I thought it would be. And one of the reasons I wanted it was to know who was there.
Oh, there you go.
I want to know if McClelland was there. He was. What doesn't show up is whether Lesenby was there. Not that it probably really matters that much, but I didn't really expect much anything different from this.
So I wonder if the November 3rd safekeeping, there has to be something on record with that, right? There has to be, even if Rick's not there without an attorney, they still have to have something on the record that they're meeting and having this and signing off on all of this, right? There should still be a transcript for it.
No.
Or they just go in the office and he just signs it and that's all there is? There's no record of it?
So
of like what are they using to prove that he needs to go to safekeeping?
Lesenby's request.
But he doesn't have to show any proof of that?
He does. He does, but he does. So that's one of the complaints in the motion to correct error. So if you sign a verified pleading, it's as if you're testifying because you're signing it under penalty for perjury, right? So you're including facts. His request for a safekeeping order is not verified. So as the motion to correct error says, there's literally no evidence in front of Diener because he didn't verify the thing. It's just a motion, and it's kind of like some of McClelland's motions where he's like making all these wild factual claims and they're not verified pleadings, and it's like Gull is taking them as true, and I just don't know how she does that. And And I'll give you an example. I think it's an unverified pleading where he tries to keep out the geofencing evidence and just says it's wildly inaccurate, and he just says it. I mean, there's no like affidavit from an expert. His pleading isn't verified, so it's not even him testifying that it's inaccurate. But Gall just, no hearing, and I'm just going to assume it's all true. And this guy who's a lawyer in small town Indiana just knows all about geofencing. So to go back to the safekeeping order, no, the only thing that thing consisted of was, so the statute allows, among other people, the sheriff to file a motion requesting a safekeeping order. And Lesenby filed that on the 3rd. Diener signed the order on the 3rd. That's all it was.
So there's no procedural record for anything. It's just, here it is, and this is it. That's it.
No, that is the procedural record.
But I'm just saying, like, there's no transcript of anything to be able to get from that. Then it's just, they just don't do anything. They just walk in, sign it, and that's it.
No, and a lot of people, I think, maybe they've stopped, but for a long time, people keep talking about the safekeeping hearing. There was no hearing. There was no hearing. That's why the motion to correct error talks about the safekeeping proceeding.
I still think there should be some, like, there should still be something that shows that, like, what transpired, like how we got there. But
how we got there is he filed. It's the same way that all the stuff, like Brad, Andy, and Jennifer would file a motion, right? And Gull would deny it. That's how we got there. Lesenby filed the motion, the request for the safekeeping order, and Diener granted it. That's how we got there.
There's not another requirement, though. That's my point. Like, I'm thinking like there should be more to it. So I guess that's your motion to correct error, and that's what we got to wait and see if they decide to have a hearing and hear what the argument is.
So to me, the statute requires a finding of one of a number of things by a judge, a finding. And so that means facts. You got to find some facts to justify a safekeeping order. And for me, that means there has to be a hearing, because there has to be evidence that supports the factual finding that the judge is going to make. So by implication, I think that the statute requires a hearing. All I can tell you.
Okay, so we agree. But there wasn't one, and so here we are.
And there you have it.
Okay. So I'll keep you posted on all the other stuff when she responds or sends me anything updated, and I'll make sure you get it. So.
Okay. Thanks.
Always. Thank you for coming on.
Okay. Bye.
All right. Bye. All right, you guys, I'm going to wrap this up. Thank you guys for being here. I always appreciate you. Go and enjoy the rest of your Friday and your weekend. And I will see you guys. Monday. I don't know if I have time to do one this weekend, but I will see you guys Monday, and we'll figure out what we're going to talk about then. So, as always, I know you have 1,000 other places that you could spend your time, and you choose to spend your time here hanging out with us. And I appreciate you guys more than words can say. Go enjoy your weekend. Have a good one.
Do you dare to follow me down? Head into the unknown. Down the rabbit hole. Where it stops, no